23rd meeting of the Charleston County Board of Zoning and Appeals, also known as the BZA. The board members that will hear your case tonight are myself. I'm William Ray. I'm the chairperson. To my right, we have Mr. Jordan, Mr. Marchant, Mr. Seedale, Mr. Neal. To my left, we have Mr. Nelson, Mr. Truslow, Mr. Williams, and Ms. Switzer Small should be en route. And to my immediate right, we have our, can we turn that back up? Our attorney, Mr. Kevin Hughey. Staff members present tonight, Ms. Sally Brooks, Ms. Clark, Mr. Downing, Mr. Foster, and Ms. Jenny Working. Because tonight is a public fact-finding meeting, we're in compliance with the Freedom of Information Act and South Carolina Code 6-29-70. 15 days prior to the hearing, an announcement was printed in the Post and Courier. A sign was posted on or near the designated property. A notice was mailed to the applicant or the applicant's representative, to the property's owners within 300 feet of the property, and to parties of interest. Persons, organizations, news media that have expressed an interest in this meeting have also been notified. Board members, the meeting notes for June 5th and June 26th, public hearing were mailed to you. Are there any questions? If I don't have any questions, can I get a motion to approve in a second?
So moved.
Second.
All right, I heard a second from down here. Mr. Williams with a second. Okay, thank you. All those in favor, please indicate by saying aye and raising your right hand.
Aye.
Aye. Any opposed? Very good, it carries. Our case ruling from this and any BZA meeting are available to the public for review and inspection during normal business hours of the Charleston County and Planning Department. The Board of Zoning and Appeals is a quasi-judicial body that has final decision-making authority on appeals of a zoning-related administrative decision. The BZA is authorized to hear and decide appeals only on zoning-related matters where it is alleged that an error was in order, required a decision or determination made by the administrative official in the administration or the enforcement of a zoning-related regulation. A 2/3 vote of quorum is required to overturn the decision made by the planning director in an appeal. We also have special exceptions. A special exception is issued by the BZA authorizing a particular use in a specified location within the zoning district upon demonstrating that such use complies with all the conditions and standards specified in the Zoning and Land Development Regulation Ordinance, also known as ZELDAR. The BZA must find that a special exception meets all 6 of the approval criteria in the ordinance to grant a special exception. A simple majority is required to grant a special exception. We have variances. A variance is a relaxation of the BZA's regulations of the ordinance, where such action will not be in contrary to the public's interest and where the conditions to the property and the results of the actions or situation of the applicant, a literal enforcement of this code would result in an unnecessary and undue hardship. And such variance is consistent with Section 6-29-800 of the Code of Law of the State of South Carolina, Title 6, Chapter 29. The BZA must find that the variance request meets all 7 of the approval criteria of the ordinance in order to grant a variance. A simple majority is required to grant a variance. Our purpose tonight is for interested parties to be heard in order to assist this board in gathering evidence pertinent to each case. If a member of the BZA finds the need for further information to clarify a case, the board has the authority to subpoena witnesses. If it must be understood that the rules of your neighborhood or your subdivision are binding and that we can take no action to negate their jurisdiction over your property. In addition to your testimony, our board has been presented written information submitted by staff, by the applicant or the applicant's agent for each case. This information is now considered to be evidence and is entered into this body for record. It is assumed that it is complete, true, and accurate. In addition, we have been presented data assembled by staff for the purpose of clarifying the location and the application effect on surrounding properties. Our board is empowered to approve with conditions, or deny a special exception or a variance. We are also authorized to defer a case should there be a need to obtain additional information. The BZA's final decision will be mailed within 10 working days of this public hearing. It will be mailed, certified mail to the applicants and U.S. mail to neighbors and the community of interest. If an applicant's request is approved, the applicant should contact the Charleston County Zoning and Planning Department staff to discuss the next steps in the process. Variances and special exceptions granted this evening are valid for 12 months after the meeting. A one-year extension may be granted only if construction or development has been commenced or is being diligently pursued. However, if an applicant request is disapproved and the applicant wishes to appeal the decision of this board concerning the case, appeal must be addressed to the circuit court. South Carolina Code 6-29-820 states that appeal must be filed by the applicant within 30 days after the decision of this board was mailed to them. Failure to file the appeal within the time limit deprives this court of the jurisdiction to hear the matter. Because this is a quasi-judicial body, everything in this meeting must be complete, true, and accurate. All the information provided to the BZA is considered evidence, and this board may certify contempt of circuit court if false statements are made either in writing or orally. Each person who wishes to address this board will be asked to be sworn in by the secretary before providing testimony or evidence. In order to expedite this procedure, those wishing to speak to this board, I would ask that you please stand as a group, and Ms. Working will administer the oath.
If you can please stand and raise your right hand, I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do. Thank you.
Thank you, Ms. Working. I will now call each case by case number. Staff will present facts pertinent to each case limited to 5 minutes. I will then call the applicant. The applicant will stand and state his or her name and address, current address, for the record before presenting testimony pertinent to the case limited to 5 minutes. I would then ask for those speaking in support or in opposition for the case, and they will follow the same procedure in identifying themselves and are limited to 2 minutes each. The applicant will then have a chance to reply to the opposition, limited to 2 minutes, and then the BZA will make a motion to close the case to the public. Finally, the BZA will make a motion concerning the application and state specific facts of finding and conclusion of law. Tonight, ladies and gentlemen, we will hear 7 new cases. Our first case will be administered by Mr. Downey. It will be case BZA 06-23-00684. If you would, we won't be looking back at these screens very much, ladies and gentlemen. We do have a screen here in front, so if you see us not looking back, it's not like we don't care, but we have a screen in front of us. Thank you. Mr. Downey.
All right, good evening. BZA case 05-23-00676. The applicant property owner, Amy Sedgwick, is requesting a variance to reduce the 50-foot front street setback by 14.5 feet to 35.5 feet for an existing, to 35.5 feet for an existing unpermitted pole barn, and by 36 feet to 14 feet for an existing unpermitted carport at 1243 Dog Patch Lane, TMS number 280000010 141 on Johns Island in Charleston County. The subject property and all surrounding properties are in the rural residential zoning district. In the applicant's letter of intent, it does give an explanation that both of the pole barns were the pole barn and the carport were placed there on the property in 1991. That is consistent with what Charleston County has recorded in the tax records. So that is the subject property. And that is an aerial view of the subject property. That's a zoomed out aerial view of the subject property. Staff did conduct a site visit on June the 22nd. So those are pictures of the existing unpermitted pole barn and carport. That is Dog Patch Lane. Also, according to Charleston County's documentation, the plat was recorded in 2005, and that's when Dog Patch Lane was, that's when the road in which the setback is being measured from was recorded in 2005, and both of those structures had already existed. That is the site plan. And again, that is the plat that was recorded in 2005. So staff believes that criteria one has, it meets criteria 1, it meets criteria 2, it meets criteria 3, it meets criteria 4, it meets criteria 5, meets criteria 6, and it may meet criteria 7. So the Board of Zoning Appeals may approve with conditions, or deny BZA case 05-23-00676, a variance to reduce the 50-foot required front street setback by 14.5 feet to 35.5 feet for an existing unpermitted pole barn by 36, and for a pole barn by 36 feet to 14 feet for an existing unpermitted carport at 1243 Dog Patch Lane, TMS number 280000141 on Johns Island in Charleston County, based on the BZA's finding of fact, unless additional information is deemed necessary to make an informed decision. In the event that the board decides to approve this application, the board should consider this recommendation by staff that the applicant shall obtain all necessary permits for the pole barn and carport. Any questions?
Any questions? Any questions, staff? I saw Mr. Marchant hand go up, then I'll get with you, Mr. Downey.
Thank you, Mr. Chairman. Mr. Downey, what applicable permits would be required since they're already in place? Just acknowledging that they've been built? I mean,
So the pole barn and the carport do not have any permits at all.
right?
That's what's going to need to be permitted once the variances.
For modification, construction?
Correct.
It's just a
Correct.
acknowledgement of existing?
Yes,
Okay.
it would be a retroactive permit.
Okay, thank you.
Yes, sir.
Mr. Neal?
On the same line, Mr. Downey, how did we get here? Is this something that was in compliance and non-compliance, and they're being fined for it or something
I
like that?
believe, I'm not 100% sure, but I believe they were doing some new construction on the property, and then we found out that there was something, neither one of these structures were permitted, and I believe that's what brings us here tonight.
Great, thank you.
Anyone else here on my left? No? No other questions? Thank you. Is the applicant available? Yes, ma'am. If you would, please come to the podium. Please state your name and address for the record, and please tell us why we should approve your application.
Amy Sedgwick, 1243 Dog Patch Lane, Johns Island. As was said, the buildings have been there since '91, and that was before the road that's in front of the buildings was there. It was family-owned property. My mother-in-law owned the 18 acres back there. It's down a half-mile dirt road, and the road that's in front of us wasn't there at the time. That was made later on. There was actually an easement that went through our property down to her home, And that was changed later on, and that's why the one is in front of us now, in front of the buildings. So, that makes sense.
Okay. Okay. So it's just been there a long while then?
Yeah, it's been there.
Okay. All right. Let's see if it, okay. We have some board members that have questions for you,
Okay.
Mr. Siddall. Go ahead.
Mr. Chairman. Ms. Sedgwick,
Yes.
in the application you meant.
Turn your mic on. There you go.
Is it on?
Yes, on the green light.
All right. Ms. Sedgwick, in the application you mentioned that you stored equipment in the pole barn, and that was for maintaining the road. Do you maintain Dogpatch Road with the equipment?
A portion of it is maintained by the county, but where the 18 acres had started, actually a little bit before that, is all privately owned, and so we maintain that portion of it. Yeah.
All right, thank you.
Mr. Williams?
Hi, so do you live in this property?
Yes.
Okay, all right, thank you.
Was it, did I see your hand down there too? Anyone else have a question of the applicant? Thank you so very much for your testimony
Thank
tonight.
you.
Do we have anyone else to speak in favor of this application? You had your hand up, sir. If you would, please, state your name and address for the record.
I'm Ty Sedgwick, husband of Amy, 1243 Dogpatch Lane. In addition to that, I just wanted to add that the property had been in the family for years, so the whole 18 acres. So over time, the lines have changed. I mean, that's why you're seeing what you're seeing now. In addition to that, the pole barn and such, of course, was there in 91, which was used always to maintain the road, as Amy had mentioned earlier. So basically, the lines have changed so much over the time, and I believe Mr. Downey saw that as well when he came out and he met with me. So just to add to that.
Okay. Let me see if anyone have any questions for you. Anyone? Mr.
Well,
Williams?
just a quick question, sir.
Sure.
So are you all building anything around that barn area, or
No.
why? Okay.
Nothing's being built there at all. I believe the picture he just showed recently, it shows everything around there. I mean, that's existing and the way it's been and has been.
So like you said, that is a good question. We're trying to figure out how it got to
Sure.
our doorstep. And so you're not doing any construction or anything?
No, there's no new construction. What happened is my son-in-law just moved into town. He applied for a business license for Charleston County. He was staying in a camper at the time on the property, and so they sent Mr. Chenoweth out immediately the next day to investigate. So that's why we're here where we're at.
There we go. There we go. It comes out. I know you keep prodding it. It come on out there.
I'll tell you.
Okay. Well, very good. Anyone else? Good. Yes, sir, Mr. Jordan.
So what is the status of that business?
I believe he got his business license, so
Can you tell us what it is? What the
flooring
is?
business.
What the business is?
I'm sorry?
What is the business?
It's a flooring business. Yes, sir.
Thank you.
Uh-huh.
Okay. Anyone else? Thank you so very much, sir, for your testimony. Does anyone else want to speak in favor of this application? Does anyone else want to speak in favor? Do we have anyone to speak in opposition to this case? Do we have anyone to speak in opposition? Okay. Very good, then. This case is closed to the public. Board members, do we have any questions of staff? Do we have any discussion? All right, gentlemen. Then I need a motion. Oh, okay. To approve.
Chairman, I move in the matter of BZA case 0523000676 that we approve this variance. I find that there were extraordinary and exceptional conditions as this building was built several years prior to the road being construction against which the setbacks were set. That the conditions don't apply to other structures in this vicinity, which meets criteria number 2. That if application of this ordinance would effectively prohibit and unreasonably restrict the utilization of the property. It's been used as a barn and, as we heard, used to maintain equipment that was stored there for the maintenance of the road. There is no substantial detriment in criteria number 4 to the adjacent property. In fact, we have letters of support from adjacent property owners in support of this. It does not establish a use not permitted in this zoning district, so it meets criteria number 5. The need for the variance is not the result of the applicant's own actions because the road was built after the buildings were constructed, and it does not substantially conflict with the comprehensive plan because it would create unreasonable, the demolition is going to be an unreasonable action to that. So for those reasons, I think we should approve the motion.
And your condition? Any other conditions, staff conditions?
Oh, no, I don't think there's any other staff conditions.
There's one condition.
There's one
There
condition.
one? I'm sorry, I didn't. What is that staff condition?
Just say to include staff.
That they-
conditions.
Oh, I'm sorry, include the staff conditions. My apologies.
That's okay.
Second.
You got a second real quick. Okay. All those in favor, please indicate by saying aye. Raise your right hand. Aye. Any opposed? No, it carries. Congratulations. Your application has been approved. You will be getting information from staff within the next 10 days, letting you know exactly what you need to do to move forward. Once again, congratulations. Okay. Ladies and gentlemen, the next case that we have will be done by Mr. Dowling again. Case BZA 678. Ladies and gentlemen, also, you noticed on these projectors behind us, when you were up and you were speaking, you were being timed. So we ask that you respect the time that you have. You see the time that we'll count down, and so we try to hold you accountable to that whenever you start to speak, okay? Go ahead, Mr. Dowling, if you would.
All right. BZA case 06-23-00678. The applicant and property owner, Catherine and Jeff Singletary, represented by Michael Spivey of Spivey Architects, are requesting a variance to reduce the 35-foot OCRM critical line setback for a new exterior open stairs to grade, exterior open deck, covered porch, elevator addition, and proposed expansion of the existing screen porch at 250 Wapu Road, TMS number 35015000025 in the St. Andrews area of Charleston County. The subject property and surrounding properties are located in the low-density R4 zoning district. In your packet, with your staff review, it has the exact breakdown of each of the variance setbacks. It says to reduce the 35-foot critical line setback by 19 feet to 16 feet at the closest point for the new exterior open stairs to grade, 19 feet to 16 feet at the closest point for the new exterior open deck, 10.1 feet to 24.9 feet at the closest point for a new covered open porch, 8.1 feet to 26.9 feet at the closest point for a new elevator addition, and to reduce the 35-foot critical line setback by 19.9 feet to 15.1 feet at the closest point for a proposed expansion of the existing screen porch. The parcel was platted in 1987, and Charleston County adopted the required setbacks and buffers for the OCRM in 2001. The subject property contains an existing single-family residence. In your packet, it also has the applicant's letter of intent, and it is quoted in the staff report. So that is the picture of the subject property. Some aerial views of the subject property. Staff did conduct a site visit on the 22nd of June. So that is the subject property. More pictures of the subject property. Wapu Road. And then these are some photos provided by the applicant. This also shows the elevation that was provided by the applicant. A survey and the site plan. And the site plan is in your packet on page 25 for you guys to get a better look at it and zoom it in. And the plat that was recorded. So staff believes that the applicant meets criteria 1. They may meet criteria 2 and 3. They also may meet criteria 4, that it meets criteria 5, it may meet criteria 6, and it may meet criteria 7. So the Board of Zoning Appeals may approve with conditions, or deny BZA case 06-23-00678, a variance to reduce 35-foot OCRM critical line setback for a new existing open stairs to grade, an existing open deck, a covered open porch, elevated addition, and a proposed expansion of the existing screen porch at 250 Wapu Road, TMS number 35015000025 in the St. Andrews area of Charleston County, based on the BZA's finding of fact, unless additional information is deemed necessary to make an informed decision. In the event that the board decides to approve this application, the board should consider the following recommendations by staff. Prior to the commencing construction, a silt fence shall be installed along the critical line. The silt fence shall be maintained throughout the duration of the construction. The required 35-foot OCRM critical line buffer shall be maintained pursuant to the Charleston County Zoning and Land Regulations Ordinance, Section 4.24.7. The applicant shall coordinate with Charleston County Public Works Stormwater Division to address stormwater mitigation measures such as the use of rain barrels, rain gardens to reduce the flow of stormwater into the marsh. Documentation of the approval measures shall be submitted as a part of the zoning permit application, and the encroachment areas shall be limited to the footprint areas shown on the submitted site plan. Are there any questions?
Any question, Mr. Nelson? Not Nelson. Neil, I'm sorry.
That's okay. I was looking around saying, anybody else? I just want to make sure I'm on the right page with the terms. Are we talking buffer here? Are we talking setback? Or are we talking both? And the second part of my question is, have any of those changed in regulations over the past years where we have a new buffer and setback versus ones we had 10 or 20 years ago or something like that?
So from my understanding, Mr. Neal, this is just talking about the setbacks, not the buffer. As far as the regulations change, I do not believe in the most recent years that we have had many significant changes to the OCRM setbacks and buffers in the R4 zoning district.
And this is just for the setback. The buffer is still in place?
The buffer is still in place,
Okay.
yes, sir.
All right, thank you.
Mr. Marchant?
Thank you, Mr. Chairman. Mr. Downey, my question is somewhat related to the last case. And in this case, would applicable permits also have to be acquired? Because that was not one of your conditions. And I'm assuming you'd have to do the same for the existing house since it's non-conforming, since the regulations changed in 2001. Is that correct?
That is correct. And if you would be so inclined, if this application was to be improved, you could add that as a fifth condition.
Okay, thank you.
Always on point. Anyone down here on my left? Mr. Nessler?
Mr. Downey, just one kind of clarification question. This application actually covers 2 TMS numbers, is that correct?
No, sir. It only covers one TMS number, TMS 35015000025.
Okay, because it appears that the house is actually on 027, when you look at aerials and maps. They're owned by the same owner, so I think it's just kind of a technicality to make sure we cover our bases as we go through the process.
Can you pull that up, Ms. Working, on the screen?
So if you look on the site plan, Mr. Nelson, it might be encroaching, but I will double check, and if it is, we will make sure at the staff level to make sure that it's only on one TMS number.
Go to your TMS map, please.
It's the wetland. Yeah, the wetland is one.
Yes, sir, I'm looking at it.
And so 027 and 025 are owned by the applicant according
Correct.
to the documents. And if you look at the GIS map, actually, if you go to the next one showing the aerial, you'll see the house actually doesn't sit on 025.
I see exactly what you're talking about. We'll make sure to get that straight before anything is permitted.
Okay, thank you.
Thank you.
Anyone else? Good observation, Mr. Nelson. Anyone else? Very good. Thank you, sir. Is the applicant present? Yes, sir. Please come to the podium, state your name and address for the record, and please tell us why we should approve your application, sir. Welcome.
Hello, my name is Michael Spivey with Spivey Architects, Inc. My address is 2 Picard Way, Charleston, South Carolina, 29412. I am here as the agent for the applicant, Kathy and Jeff Singletary. They have decided, after much decision, to keep their home and age in place, and called our firm to ask us if we could figure out how to add an elevator and improve their existing screen porch. So we did take a look at it. We added the elevator as requested by the client, and then adjusted the roof line of the house to better match with the addition of the elevator. And in doing that, they requested to expand slightly their screen porch and to add an open deck, both of which I think are shown in the renderings and in the site plan. One point I would like to make is there is a very rigid straight line to the right side of the site plan. If you look at it, just want to make sure all of you knew that that is a property line to an existing piece of property on the other side of that property line that is actually inaccessible and owned by someone else. It's kind of a strange situation, but we'll make sure you understood that. And so the applicant obviously purchased the property, built the house in the early 90s when there was no setback from the critical line of any appreciable nature. At the time the original home was permitted, was all in accordance with laws at that point in time. So they're simply wanting to take a piece of property that they purchased years ago, improve their house for aging in place with the use of an elevator to get them to their second floor, which houses all their bedrooms. Other than that, I think the application is pretty straightforward. I'm happy to answer any questions anyone has.
Thank you, Mr. Spivey. Do we have anyone that has a question for the architect of record? Yes, sir.
Mr. Spivey, your client is fine with all of the recommendations that staff has made, and including the one that might be added if we were to see a positive result tonight on building permits and all the necessary bringing things to code?
I haven't really asked him about that, but he's here. He can answer that.
We'll want to hear that. And you elaborate on, you said, because I asked Mr. Downey this question, if anything had changed regulations. You're saying that when the house was purchased, the setbacks and everything was conforming, and now you're saying it's not. Could you elaborate on that? Because you're asking for a lot of variances, which are understandable. I just want to make sure.
Yeah, no, I
we
guess
y'all didn't do anything to change this.
Yeah. No, the house was designed in the early 90s. At that point in time, there were no appreciable setbacks from the critical line. So it complied with everything, building permit in place for the house, whole thing, met all laws when it was built in the early 90s. Since that time, of course, the OCRM has a greater setback. And I recall when that ordinance occurred, that older residences at the time we were told would be grandfathered in place. So basically we're here because even though technically I guess we might be grandfathered, we don't meet current regulations, so we're here just to request a variance as instructed.
Follow up, I want to confirm that you're stating that the client has no problem, that this will not go in the buffer area. We're only talking about the setback, correct?
All I'm talking about is setback. I'm not really up to speed on any actual buffer. For this piece of property, we're just asking the variance because the setback is much greater than when the property was purchased and the original house design.
Thank you, Mr. Chairman.
Thank you, sir. Anyone else? Thank you, Mr. Spivey.
Thank you.
I'm not sure if Josh mentioned or not, but the OSERM setbacks and buffers didn't exist until 2001. So, but to answer your question, there really hasn't been any changes to the distances at all.
Thank you, Ms. Working. Is there anyone else to speak in favor of this application? Is there anyone else to speak in favor of this application? Do we have anyone to speak in opposition to this application? Anyone to speak in opposition? Very good. Case is closed to the public. Board members, do you have any questions for staff? Then I need a motion to either approve or deny this case. Yes, sir.
I'll go ahead then. Mr. Chair, I move that we make a motion to approve BZA 0623-00678 item. I believe it meets all of the criteria for the zoning variances 1 through 7, all 7. I would like to include all staff comments and include an additional comment to adhere to all building new codes for building for the county.
You still have to go down all 7.
I have to go down to each 7?
Yes, sir.
All right, I believe it as part of the zoning variance, this application meets number 1. There are extraordinary exceptional conditions pertaining to a particular piece of property. I believe it meets item 2. These conditions do not generally apply to other property in the vicinity. We have nobody in opposition tonight. I believe it meets item 3 because of these conditions. The application of this ordinance, particular piece of property, which is a unique piece of property, would not unreasonably restrict the utilization of this property. I believe it meets item 4. The authorization of this variance will not be substantial detriment to the adjacent property or to the public good. I believe it meets item 5. The Board of Zoning Appeals shall not grant a variance with the effect would be allowed at the establishment of there's no use other than what the current use is. Item 6, the need for this variance is not the result of the applicant's own actions. They're just adding the elevator. So it shouldn't affect anything. The need for this, item 6, the need for this variance, his own actions, I said that. Number 7, granting of the variance does not substantially conflict with the comp plan.
Your conditions. Conditions.
I restated the staff conditions along with adding a new item that adhere with all the newest building codes for the county.
Okay. Do we have a second?
I'll second, but
You want to change you want to update that? Go ahead.
I may, Mr. Neal, would you be okay for your 5th condition to state something along the lines of, and the applicant shall obtain all necessary permits for the existing house and any addition renovations to the current property?
Stated, yes, I accept that.
You accept.
And I'll second that. Thank you.
Very good. All right. Any discussion? All right. Let's bring it to the vote. All those in favor, please indicate by saying aye and raising your right hand. Aye. It is unanimous. And nays, no nays. Okay. Very good. Mr. Spivey, sir, your application has been approved. Congratulations. You'll get information from staff within the next 10 days letting you know the next steps in the process. Congratulations. Good job, gentlemen. Our next case is case BZA 0623-00679. Mr. Downey again.
So BZA 0623 00679. The applicant and property owner, Calvin Grant, is requesting a variance to locate a detached accessory structure, a shed, in the front of the principal structure at 3180 Highway 17, TMS number 598000023 in the east area of Charleston County. The subject property and the surrounding properties are located in the Mount Pleasant Overlay Suburban Residential Zoning District. The 0.75 acre subject property contains a single-family residence, an accessory dwelling unit, a garage, and a shed. The applicant's letter of intent explains, I am requesting, sending this email request to obtain a variance for a shed that was built in the front of my parcel, TMS number 598000023. I was unaware of the requirements to obtain a permit for the shed prior to having it built. It would be difficult to, and a strain for my fiance, or my finances, to have it removed. If I could receive assistance with this issue, it would be greatly appreciated. So that is section 6.5.8. Where it talks about accessory structures for residential and office residential zoning districts, and it states that detached accessory structures must be to the rear of the principal structure. Again, the property is in the Mount Pleasant Overlay Suburban Residential Zoning District, and this is a copy of that map. Here is the subject property when looking at a zoning map, and that is an aerial view of the subject property, a zoomed out aerial view of the subject property. So staff did conduct a site visit on the 22nd of June. Here are pictures of the accessory structure, the shed. So, as staff was was drafting this staff report and doing its research for this application, it was discovered that the accessory structure was placed on a concrete pad that existed prior to 2001, and it's shown in the 2001 aerial view. So here is a picture of the 2001 aerial of that property. So these are the additions, the additional structures on the property and Highway 17. So here is a site plan and the plat. So staff believes that criteria 1 has been met. Criteria 2 and 3 have been met. It may meet criteria 4. It meets criteria 5, it may meet criteria 6, and it may meet criteria 7. So the Board of Zoning Appeals may approve with conditions, or deny BZA case 0623-00679, a variance request to locate the detached accessory structure, a shed, in the front of the principal structure at 3180 Highway 17 North, TMS number 598000023 in the east area of Charleston County, based on the BZA's finding of fact, unless additional information is deemed necessary to make an informed decision. In the event that the board decides to approve this application, the board should consider the following recommendation by staff, and that is that the applicant shall obtain all necessary permits for the shed. Any questions?
Any questions, staff? Yes, sir, Mr. Marchant.
Thank you, Mr. Chairman. Mr. Downey, can you timeline this for us one more time? So in 2001, there was a concrete pad.
It was a concrete pad in
in
2001.
location. And then at some point, the shed got built.
Between 2001 and 2009, we're not exactly sure when it was constructed because we don't have the tax records for it. If so, I would have made sure to include that in the report, but we're not sure, and that may be a question for the applicant, but the shed was placed on the concrete pad that existed prior to 2001.
The the current section of Zeldar existed at that point, at that time? In other words, was this non-conforming originally, or is it non-conforming now?
It would have been non-conforming if the shed was completely constructed, but the concrete pad was already there.
Right, okay.
Yeah. So that's where it's kind of tricky.
The trigger was a new addition to the existing house that, okay.
Correct.
Thank you.
Yes, sir.
Mr. Williams?
Question on the timeline as well. Was the applicant living there when it was built, or?
Yes.
Okay, thank you.
Any other questions? Mr. Jordan? Okay, thank you.
Thank you.
Is the applicant here? Please come forward. Please state your name and address for the record, and please tell us why we should approve this application, sir.
My name is Calvin Grant. Live at 3180 Highway 17 North in Mount Pleasant. 29466 is zip code. I've lived here at this location for 39 years. My sister lives next door to me. My uncle lives on the other side. And my cousin lives right next door. We used to call it like a four-horse town because no one else wanted to live there except for us. I'm asking the BZA to grant this one because it would be a financial nightmare for me to try to move this shed. And the only feedback I've gotten from anyone about this shed is they wanted me to build one for them, too. And I tried to build something nice there. I didn't want to put like a flat top bar there. I wanted to put something that was appeasing to the eye. That's all I can say about it.
Anyone have any questions of the applicant? Mr. Williams?
Well, quick question, sir, how you doing? So you built the shed at some point, right?
Yes.
And then you found out about the requirements at what point?
Well, I found out about it when I was building another addition, and someone called the county. Then they came, and then that's when they told me that the shed shouldn't be there. I didn't know it shouldn't be there. That used to be a basketball court for me and my son. Since he's all grown now, I figured that was the only obvious place for me to put it. I didn't want to have to build a floor system. I already had a concrete slab there, and I just built it, bolted it down to it. All my different hurricane scraps and everything that was needed for the construction.
So around June 22nd, 23? You have a recent build, right?
It's recently built, yes.
Okay, thank you.
So when did you build it again?
It was this year. I'm not exactly sure what month, but it was this year.
And what are you doing with the shed?
Well, it's just a shed for me to store my tools. And sometimes I go around and do a little work. I got some cordless tools that I build little things with. It's just pretty much a storage shed.
Okay. Anyone else have a question? Thank you so very much for your testimony, sir.
Okay.
Do we have anyone else to speak in favor of this application? Do we have anyone else to speak in favor of this application? Do we have anyone to speak in opposition to this application? Do we have anyone to speak in opposition? Very good. Then this case is closed to the public. Board members, I need to have any questions? Therefore, I need to have a motion to approve or deny this case. Mr. Nelson?
Mr. Chair, in the matter of BZA 0623000679, I'll make a motion that we approve this request. I find that it does meet criterion 1, that there are extraordinary and exceptional conditions pertaining to the piece of property. The applicant's lived there for a long time, and with the concrete slab in place, it seems reasonable to put a shed on top of an existing slab. For criterion 2, the conditions do not generally apply to other properties in the vicinity. Again, due to the length of time the applicant has owned this property, and using it, I guess, as a four-horse town with his relatives, that just not necessarily something that we see in Mount Pleasant every day. Criterion 3, because of these conditions, the application of this ordinance to the particular piece of property would effectively prohibit or unreasonably restrict utilization of the property. Again, moving it would be would be detrimental to the owner's finances. So I think that forcing him to move it would be a bad form by our board. Or criterion 4, the authorization of the variance will not be of substantial detriment to the adjacent property or to the public good, and the character of the zoning district will not be harmed. Again, I feel that we meet that criterion with the location of this particular shed. For criterion 5, the BZA shall not grant a variance, the effect of which would be to allow the establishment of a use not otherwise permitted in this zoning district. We certainly meet that criterion because there's no use changes occurring. Criterion 6, the need for the variance is not the result of the applicant's own action. Again, with the concrete pad in place that had been there since at least 2001, it was reasonable that the applicant would place the shed at that location. And criterion 7, granting of the variance does not substantially conflict with the comprehensive plan or the purposes of the ordinance. In making this motion, I do believe that that we should include the one condition recommended by staff.
Okay, it's been properly moved and second. Any questions? Discussion? Very good. All those in favor indicate by saying aye and raising your right hand. Aye. Any opposed? I see none. It carries. Congratulations, your application has been approved. Within 10 days, you'll get information from staff letting you know the next steps in the process. Congratulations again. Good night. Moving right along, folks. Pretty good. Thank you.
Yes, sir.
Our next case is case BZA 06-23-00680. And I think Ms. Working will be taking care of that one for us.
The applicant, Neil Mentz of Top Notch Transport and Mobile Home Setup LLC, and the property owner, Gerardo Hernandez Silva, are requesting a variance to reduce the required 50-foot front street side setback by 35 feet to 15 feet for a proposed manufactured home on a flag lot at 3737 Marianne Point Road, and that's tax map number 253-0000277 on Johns Island in Charleston County. This is the zoning map. The subject property and surrounding properties to the north, east, and west are located in the agricultural residential AGR zoning district. The adjacent property to the south is located in the rural agricultural AG8 district. The applicant would like to put a 28 by 44 foot manufactured home on the 0.79 acre subject property. And these are the requirements. The requirement for the 50-foot setback is in Chapter 4. And then we had a written interpretation per Chapter 3, Article 3.11. And that states, in quotes, if the flagpole portion of a flag lot is not consistent, minimum buildable width of 40 feet, plus the combined side setbacks, and does not count as lot area for the purpose of meeting minimum lot requirements, the front setback shall be measured from the lot line of the bulk of the lot that is parallel to the right-of-way or easement accessed by the flagpole. So this diagram kind of shows that for you guys better. So that whole line that's parallel to the street is considered the front, and that's where the setback is measured from. And then we gave them the option to pick which one they want to be their side and which one they want to be the rear. Let's see what else. We conducted a site visit on June 22nd, 2023. We did receive one letter of opposition for this case, but we stated that it meets criteria 1, 2, and 5, and it may meet 3, 4, 6, and 7. And I didn't have any conditions for that. But this is aerial photos, subject property and surrounding properties, Marianne Point Road. And then the site plan again that shows the location, proposed location, plot. So again, they meet, in our opinion, they met 1, 2, and 5, and they may meet 3, 4, 6, and 7. And we didn't have any conditions, so the board may approve with conditions, or deny the request based on the board's findings of fact.
Any questions? Mr. Marchuk?
Thank you, Mr. Chairman. Ms. Workin, can you pull up the aerial that shows the flag lot?
This one or this one?
Keep going. The one where you had, it was like a diagram with aerial.
Oh, sorry. Yeah, that. Yeah.
So, help me understand where it says front, that's now the front setback that they're asking a variance from, correct?
Right.
That runs parallel to the road.
That's correct.
So where does it, there isn't a site plan that shows the proposed location of the manufactured home. I assume it runs sort of parallel longwise to, or is that it?
That's it.
That's it.
Okay. But it's not existing or it is existing?
It's not existing at this time.
Okay. So I guess we can ask the applicant this, but they didn't explore any other location on the lot. Are there any other restrictions on the lot?
Yeah, they'll need to answer that.
Okay.
But this is their preferred location, and in their opinion, I believe, it could be debated about our interpretation, somewhat.
Yes, sir.
Just following up Mr. Marchin's question, but it's really I'm having a hard time understanding the setback. What's conforming and then what's the variance? Because I don't know if the flag lot is being measured from the front, where's the measuring of the 50 and the 35? So I don't
So
quite understand that
The
one yet.
50, I don't know, it's behind you, but would be off this whole entire front.
Oh, that's.
And then we were going to allow them, to choose either 15 or 30 for rear or 15 and 30 for rear. And then they would like to be, these structures don't exist now. They would like to be 15 feet instead of, 35 feet instead of.
I understand it now. I thought it was off the
reduction of
flag
15
portion.
feet.
No problem.
No, it's okay.
Thank you.
It's a little confusing.
Thank
That's
you
why
for
I
that
put
clarification.
that Sally's diagram to help out, to explain.
I think Mr. Marchant had another question too.
Well, we're going to do some fuzzy math here. Yeah, Clemson math. Just looking at the survey, so the triangular vertical property line is 206 feet roughly, and the horizontal triangular side is 208 feet approximately, correct? I'm just trying to figure out, like, if you set back the front lot line, what is now the front lot line, 35 feet, kind of where, I'm trying to figure out kind of where it lands, because there's a lot of land there that's not being utilized for the building location, but I can't tell because the site plan's poor.
And I'm sorry, I think I read it correct, but I might have misspoke the second time. They are reducing it down to 15 feet. So my bad math, college Charleston math.
Yeah, okay. Having said that, though.
50 minus 35.
If we set back all these lines, it would help understand the buildable area, if you will.
I agree.
And I can't understand that, so it's hard.
Okay.
That's all.
Yes, I agree with that. Let's see. That is the 15-foot line, but you're correct, they're not showing the 35 or the 50. I think that's what you're saying, which would have been helpful to see.
Well, that blue line is the 15-foot? Okay.
Yes.
Okay, that helps a little bit.
Okay.
Thanks.
But yeah, I think I know what you're saying, that if they would have showed the 35 and the 50, that would have helped, but
Good observation.
yeah.
Any questions on my left? No? All right. Thank you, Ms. Working.
You're welcome.
Is the applicant available? Present. Very good. I want you to pull that mic down too for me, okay? Good
Hi.
afternoon. Please state your name and address for the record.
Amy
Please-
Silva for Top Notch Transport Mobile Home Setup, 3511 South Live Oak Drive, South Carolina.
All right, I'm gonna get you to say that one more time because you said that really
I'm so
quick.
sorry. I'm Amy Silva for Top Notch Transport Mobile Home Setup, 3511 South Live Oak Drive, Moncks Corner, South Carolina, 29461.
And you're representing the applicant.
Yes, sir.
All right. Please tell us why we should approve this application.
So our client has hired us to move a mobile home on that property. Being that it's a triangular lot, it's kind of challenging. His utilities are all there right in the front corner, which is why we want to the variance and have the setbacks approved for the lesser setback. I mean, I know he has a lot of land there, which was the question, but the reason is because he's got all the utilities right there in the front corner. So, and essentially the front door is really going to be at the back. So his if what Charleston County, considers the front is really the back for his property.
So,
So I think you should approve it so that he can, the way the flag lot is, he can come in, he can have a circular drive and have his house there. And all his utilities are right close to it. Otherwise, he's going to end up spending $25,000 to $30,000 more in order to just have utilities coming to the property if he moves it back to meet the required setbacks.
so is that all the utilities or just the
No, all of
septic?
them are there. Septic, electrical, and water is also like right there.
Okay. Yes, sir.
Thank you, Mr. Chairman. Yeah, I wanted to confirm, there's a septic tank. This is not a sewer system. This is a septic tank.
I believe it's a septic.
So the sewer connection is there, or the field? Do you happen to know what the field is for the sewer tank? I mean, there's a tank, and then there's usually a field
The
also.
drainage field?
And it
The
would be
drainage field,
compacted in that tight area. So it seems like you would need to pull that out from that corner a little bit more anyway.
Depending on where the drainage is, what you're saying?
Yes, ma'am.
I don't see.
I would really like to know where the location of the utilities are and stuff. Also, that would be very helpful.
Okay, so I apologize. I'm here on behalf of Neil Mintz because he's at a Berkeley County zoning meeting, so at the same time. The landowner is here. Can we ask him?
You'll get his chance. But
Okay.
you stepped up to the mic first.
I don't know the answer to that
So-
question at the moment. I'm sorry.
That's okay. You're doing good so far. You just have to take a couple questions while you're there, Mr. Marshall.
Thank you, Mr. Chairman. Ms. Silva, since we don't have a site plan, it's difficult to understand the constraints on the property. And typically, when we're looking at variance requests, we want to understand the overall constraints so that we can make a good judgment. And
Okay.
with the information presented, it sounds like and it appears like it's because the utilities are there and I want a really nice circular drive and my front door is going to face these two retention ponds, and that's why, which is hard. It's difficult to find a hardship there for me. So my question is, can you help us better understand the site constraints, whether it be septic or otherwise, that limits the location of where this building can go? Because that would help me better understand how to judge this.
Right, and I can understand that. So I don't know where the leach field is or where the drainage field is, but I know that if you look at that site plan and on the, that little triangle on the corner side is where all the utilities are right at the moment. The hardship is that it's going to be another $20,000 to $30,000 in order to move those utilities, or in order for there to reach it if we meet the setbacks that Charleston County has at the moment. So.
Mr. Nelson?
So looking at the aerial photographs for the site, there's a couple of things that noticed that maybe haven't been brought out in the application. But one, as of 2019, and even in the email that I think Ms. Brooks sent at some point, I think that was your email with the aerial photograph and front and side, that it appears there used to be a structure on the property. So there was a house in that location before? Was it
I believe before our client bought the property, which is why those utilities are there.
in that same general area?
Yes,
And then as you move to the south side of the property, are there a lot of trees? Do we know if any of those are grand trees on the south side of the property?
I don't believe they're grand trees, and I believe some of them have been cleared already, or they were previously cleared before our client bought it. So they're not within the 40 feet or whatever it is for for them to be on the site plan.
Okay. All right. Thank you.
Thank you.
Good question, Mr. Nelson. Anyone else? Thank you so very much
Thank
for your
you.
testimony. You did a good job.
Thank you.
Do we have anyone else to speak in favor of this application? Do we have anyone else to speak in favor of this application? Okay. Do we have anyone to speak in opposition of this application? Okay. Please come forward, state your name and address, and please tell us why we should deny this case.
Hi, my name's Elaine Carrizales. I live at 3707 Marianne Point Road, Johns Island, South Carolina, 29455. I believe what I was looking at, I live in front of where they're moving this mobile home. I'm not exactly sure how this works. My first time doing this. I just don't want it to affect my property. I do have oak trees in my property. I have 4 of them. There's one in the back. But I couldn't really tell on the pictures if...
Okay, hold on, let us get there, if you don't
Yeah.
mind, Ms. Working, if you can get to that overview for us, because we want to see what we're working with.
Sorry.
That same one we've been working off of.
Okay. Sorry. Okay.
That one. Which one is yours?
I live on 3707 Marianne Point Road.
So you see the numbers down there, 3727, 3733.
I can't really see them from here, but that's why I came up here, because I wasn't sure if my property is in front of theirs. Okay, all right.
So she's TMS number 120.
You TMS 120? Do you recognize your property up there?
Is it the 120?
Well,
I just can't tell.
Yeah, I think that's what.
so you see the subject property that's hashed out, right,
Yeah.
in lines.
I don't know if it's the 120 or the 200. I just can't see from here. I'm sorry.
Did that help?
Can you do the air?
What was your name again, ma'am?
Eglaine?
Trying to pull it up.
Yeah, I think it is 120, looking at Charleston County tax maps. 253-0000-120.
What's your name again?
Eglaine Carrizales?
Gonzalez.
So that's
Rodriguez. Let me go back.
Yes, that's my husband, Simri Rodriguez.
Just in both their names.
Okay. All right. So you're 120.
I'm 120.
Yes.
So I guess it's all the way on the other side.
Uh-huh.
Yep. Alrighty. That's all I needed to know. But thank you.
Thank you.
So what was the question? Did she have a statement?
But she's not adjoining to the property.
Oh.
Anyone else to speak in opposition? Is there anyone else speaking in opposition? I don't think that was a rebuttal. Okay. I think that was just mislocated. All right. At this time, this case is closed to the public. Board member, do we have any questions, staff? Any discussion?
I have a discussion question before a
Yes,
moment,
sir.
if I may. I'm having a hard time making a decision on this topic. I think we need more information, or at least from my point of view. I was wondering if the applicant or the applicant's agent would entertain a deferral for 30 days, however long our process is here, so we can get more information to see if there's a more reasonable place to put this on the property. I don't have a lot of heartache over it, but I have some, because I don't think there's a major hardship, and that's the one I'm getting stuck on. But I don't want to defer if we're just going to, we don't see that there's possibility for this down the road. But I'd hate to close the door on them, and I don't know how they can come back and make something out. That's just where I am on this issue. So I would be open to support of deferral of some type, but I'm easy to convince otherwise.
Yeah, they would have to request a deferral.
But can't this board bring, I apologize, can't this board bring up a deferral and say we would like this
You can
more
request
more
additional
data?
They can
information.
request it, but they still have to
No, you
accept-
could request,
No, we
you don't
can-
have to make a decision. You
Okay.
could request additional information if you
Okay,
cannot make.
you're
a
right, thank you. I apologize, thank you.
The issues, I think, are the site plan. It's the 15 feet, the 35 feet, where are the utilities, where are the drain fields, where other options can we put this? And if they choose not to, and if they come back and say, well, it is 20,000 or 30,000 or 50,000 to relocate, okay, then that would meet the hardship requirement. That's what I'd like to see. But if I'm in the minority, I'm fine too.
Mr. Go ahead.
I'd like to know if the deferral issue is under consideration, which it is. Does
Yeah.
this lady understand that process, and knows that she has that right to do that?
Yeah, she's hearing it right now, yeah.
I mean, she could ask y'all to vote tonight, but ultimately it's your decision, like vote it up or down, but ultimately it's your decision if you feel more comfortable waiting a couple months. I would point out that you guys cannot consider finances.
Right.
I mean, you can consider it, but it can't be a part of your decision.
Can't be part of it.
Because the criteria one has to do with the property conditions. What's unique about the property, not about financial, it's not financial hardships.
The hardship could be moving,
Right.
extending,
Yes.
Having
but
to
it
move.
cannot be the cost.
Yes,
So
agreed.
Thank you.
Is the owner here? I'm just curious. Property owner?
Yes, she's nodding her head, so the owner is
She
here.
has her hand up too.
no, there was a question.
Yeah, the question was the owner here? And
Is he
she
here from
nodded
the
her
property
head.
owner? by chance?
Well, he,
She said he was at her birthday county.
The property owner?
Chairman.
so,
May I ask staff a question?
go ahead.
I understand Ms. Silva to be the agent, correct? Not the property owner? She's listed as the property owner in
Yes.
the application, but
Yes, that's what I thought.
she's the agent.
But she said she worked for Top Notch.
Yeah, mobile home company.
Understand.
Top Notch.
And the owner of the property is Mr. Mintz, who's, I guess the owner.
Oh,
okay, no, okay. The property owner is absent from the hearing, correct?
Let me see.
We all agree with that.
What, didn't we pull up that she was? Oh, that was a neighbor. Okay, yeah.
Well, my mic isn't working. But anyway, I'll be loud.
Well, the county, the deed says that, that's the owner, Silva. And that's who signed the application. That's what GIS and the deeds say.
Home occupant will not be the owner. It will be someone else who's
I
not here.
don't know that.
Okay.
And answer, if it will be rented or purchased from somebody else.
I heard suggested that the person that owned the property wasn't able to be here. That's
That's
why
what
I'm
I
asking
heard,
the
too.
question.
Yeah,
So-
I heard that too.
Okay. So having
Little confusing.
having not understanding anything, I also am in the camp with Mr. Neal. I mean, I don't care whether someone makes a motion to approve or deny. I'm going to abstain because I just don't feel like I can make a decision based on the information that's been presented. So for what it's worth.
And that's who signed the application as owner. But
So I'll put a stake in it. So at this time, I'll make a motion. If we don't have any other discussion, I'll make a motion that we defer this case for up to 60 days until we can get more clarification on the lot location and the location that the mobile home needs to be in, so that this board can make a sound decision.
Sorry.
I second that.
Mr. Chair, I'm sorry.
Go ahead.
Would you include in your motion the data that we need, or that we would request, would include a site plan with all of the current setbacks and the location of all utilities and sewer applicable?
I will, yes.
Trees, access, yeah.
Yes. So to restate that is that we will defer the case up to 60 days or whenever staff can place it on the agenda, that we can get the proper site plan with the necessary setbacks and everything that is required so that this board can make its determination.
are allowed to defer up to 90 days. I know for sure it can't go in August. I'll talk about that later. They might be able to get it in September, but again, that's going to be up to them providing information to us. So it could be
So up to
September
90
or
days.
October.
So-
Up to 90 days, is that okay?
Yeah, 90 days.
Okay.
Yeah.
But I'm flexible. I mean, I could get them on September if they have the information in time.
So we have a motion that's been properly moved and seconded. Any discussion? Mr. Jordan?
For whatever reason, you can't have a meeting in August. That's not their fault, though, is it?
No, we're meeting in August. It's a full agenda. I've already had people apply for September.
Okay,
'cause
but
they couldn't
again,
get
that's
them.
not her fault.
Correct. I'm just letting y'all know that I wouldn't be able to schedule this case, so you guys know that it won't be heard in August if you defer. That's all.
Trying to make sure that.
And you have.
this is fair. We're
Yeah,
fair
of
towards her.
course, yeah. We usually do up to 90 days just to allow flexibility, because if there is a chance I can get her in August, I could, but right now I could say the answer would be no,
Thank you.
unless something changes.
Any more discussion?
Well, it seems that there's no prejudice to the applicant by deferring, as has been suggested, and it seems intimately fair to me. And I thought both gentlemen made very good points.
That's why we had this wonderful board. Don't you just love it?
Thank you.
Yes.
Good point, Sam. There you go.
All right. With time in mind. All those in favor, please indicate by saying aye. And raise your right hand. Any opposed? Very good, it carries. Your application has been deferred. You'll be getting information from staff, letting you know when you can reappear to this board with the necessary information. Please, please work with Ms. Working to get all the information so you can come back to us as quickly as possible, okay? Thank you. We're doing good on time. We're an hour and 15 minutes in. We're going to keep moving along.
What's our, Mr. Chairman, our next case, approximate timeline on that one? Just looking for a break now or later?
Do we need to? Okay. Let's do this then. Let's take a 10-minute break. And we'll come back, reconvene at that time.
Here for a long time, too.
I'll stretch my legs.
10 minutes. Let's be back in 10 minutes.
If I remember to bring them.
At 6:30.
Everybody else is taking a break.
Make it back.
Okay, I think we're all ready to go. Our next case will be done by Ms. Working. It'll be case BZA. Well, let's open this back up. So our next case that we have is case BZA 0623-00681. Thank you.
The applicant and property owner, Carla Korn, is requesting a special exception for placement of 2 manufactured housing units in the low-density residential R4 zoning district at 1739 and 1741 West Avalon Circle, and that's TMS number 352-13-00109 in the St. Andrews area of Charleston County. Adjacent properties to the north and south are also located in the low-density residential R4 zoning district. They're shown in yellow on the zoning map. The adjacent property to the west is located in the general office GO zoning district. It's shown in pink. It kind of looks white on this map. And then anything in green on the map is the city of Charleston jurisdiction. The subject property is 0.32 acres. It's currently vacant. The property previously had a manufactured home on it. However, a zoning permit was pulled in 2018 to demolish that home. That manufactured home appears on the approved and recorded plat, the 1999 plat, and also on aerials up until 2017. This is the requirement that they did not meet the 25% required in Chapter 6. So, staff analyzed the properties within 300 feet. That's this big red circle of the parcel proposed for the manufactured home placement on April 25th. And we determined that of the 32 parcels within the 300-foot subject area, there were 23 existing residences, 12 site-built, 5 multifamily, 5 duplexes or triplexes, and 1 manufactured home. And I have circled that manufactured home location with a little red circle on this map, parcel 96. So based on those findings, the manufactured home ratio for this subject area is 0.08%, so it did not meet our 25%. And in addition, there are 3 parcels that are commercial and 6 that are vacant that aren't included in that analysis. We conducted a site visit on June 22nd, 2023. And this is the aerial photographs. Okay. Subject property and surrounding properties, the site-built homes. And this is the 1 manufactured home on that parcel that I mentioned. And just a couple photographs of West Avalon Circle. This is some photographs provided by the applicant. And the site plan, it is a little light. I think it was done in pencil. And then we have the plat. And like I said earlier, you could see that mobile home on the 99 plat. Staff stated in the report that we thought the request at that time meets all criteria. Since then, we have received, in your packet, your supplemental packet, were 4 letters of opposition for this case. And the board can approve of conditions, or deny the special exception based on the board's findings of criteria 1 through 6. If you do choose to approve, we have 1 condition recommended, that the manufactured home shall comply with section 6424B of the Charleston County Zoning and Land Development Regulations Ordinance. That concludes my report.
Okay, thank you, Ms. Working. Do we have any board members with a question? No? Thank you so very much. Is the applicant present? Yes, ma'am. Please come forward and tell us why we should approve your application.
Hi, my name is Carla Korn. I live at 822 Trent Street, Charleston, South Carolina, 29414. This property, I used to live there in that trailer that was there. The gentleman that owned it died, and I bought the piece of property from him. The trailer that was there was very, very old, but that's where I could live and what I could afford at the time. Anyway, I moved out of there, and the trailer that was there got dilapidated. And so I saved up a couple of $1,000 is what it cost to tear it down. And to move it all out. Well, since I moved it all out, all these little, and we mowed it and got it all nice and clean, and it was pretty. And then, you know that when you don't take care of the property like you're supposed to, trees start to grow up. So they had little saplings all over the place growing up, and then they got bigger and bigger and bigger, of course. There is a grand oak tree on the property that won't be touched. I bought this piece of property because I was going to retire there, but I don't make that much money, so I've been saving in order to do what I'm able to do now. And I thought that it would be good to live in one and then rent the other one out. But until I get to that point, I would rent them both out. My idea was to get rid of all of those saplings and all that stuff. I put, I'm looking at the time, and put the gravel down so that there wasn't all that maintenance, because that was very expensive, the maintenance, and I couldn't do it, couldn't afford it. So that was why I wanted to do that there. I had several, just one person wrote a letter, and then another one had a trailer or modular home on the marsh. And then there is a manufactured home 2 spots over from me in a very, very big lot, but they're calling that a house, and it's not, it's a mobile home. But it's okay, you know, I don't mind. Right now, the place looks really bad, and it's an eyesore and I feel terrible about it too. But I finally got an option that I can clean this up and make it look nice. And we're gonna put 8-foot privacy fence around 3/4 of it, and all gravel, like I said, and then the grand oak tree. And it's gonna be so much better than what I have since I bought it in 2000. It's shameful. It's a beautiful piece of property, and I just wanted to try to make it look nice again, like it used to. Do y'all have any questions for me?
Well, thank you. I'm sure that someone up here does. Does anyone? Ms. Smalls? No? Anyone? All right. Well, thank you so very much for your testimony today. No one has a question for you.
Thank you.
Does anyone else want to speak in favor for this application? Do we have anyone else to speak in favor of this application?
No, we're getting ready to get on.
Do we have anyone to speak in opposition
Oh, yeah.
for this app? Okay. I saw a couple hands go up one time. How about ladies first?
All of them were not sworn in.
Okay. Now, I'll also ask this group, have you guys been sworn in?
No, I think,
You have not?
I don't believe so. I signed in. Is that-
Okay. Signing and sworn in are 2 different things.
Oh,
So, thank you.
I do.
Thank you. Please state your name and address for the record, and please tell us why we should deny this case.
Sure. My name is Hannah Cook. I live at 1549 North Avalon Circle, Charleston, South Carolina, 29407. I live in the corner lot, which is directly opposite of the proposed lot. A couple reasons. So I think actually the applicant mentioned my primary concern, which is I'm not sure the size of the dwelling that is anticipated, but let's say, for example, 3-2. That would mean that if you're renting, that's a likelihood of up to 12 adults on a very small piece of property. If you noticed on the map that was shown, the closest mobile home is the tiniest little margin of land in the outskirt of that circle. Our corner is incredibly quiet, incredibly well kept. I would actually argue against the applicant's point that the lot is an eyesore. That grand tree is home to lots of wildlife, including several different owls.
which are a wonderful part of the neighborhood and the community. And I think anyone who knows anything about ecology would understand that when you begin to segment land, that a grand tree that is surrounded by nothing but gravel and 8-foot privacy fences probably is a little bit less grand. I would also point out that if you were to tour the rest of the neighborhood, you would see that there are some high turnover multifamily units, and in those portions of the neighborhood, the amount of litter, which is a byproduct of maybe, I don't want to assume, maybe lack of care, maybe evictions, but it's much, we pick up a lot of trash when we walk our dogs. And so we would like to see that particular affliction not come to our corner. And I would also like to point out that it's not an opposition to mobile homes for me. It's an opposition to high-density multifamily living in a very small parcel of land that is a really beautiful part of the local ecosystem, which also I'm not sure that it actually touches, but it's very close to an area that was recently deemed, I forget the term, but like a wildlife habitat marshland. And so it would be nice to see someone take over that space that wanted to maintain that sort of mindset for the property.
Okay.
Thank you.
Now, let me ask a question.
Sure.
You stated your address. Ms. Working, could you pull up the map? I like to see where people reside.
Sure. Oh, you passed my house.
Okay, right there.
121.
You're 121. Okay,
Yes,
so
sir.
you're across the street from
Yes,
it there.
sir.
All right. And the duplexes are right across the street as well, somewhat, that we have.
Somewhat, yeah. But
And-
again, those are, I mean,
I'm sorry, say again?
yes, not directly across the street, but they are kind of.
Quarter
Yeah.
for you. And what kind of experience have you had with those units that there have been in the past with you? Have you had any opposition with them?
With individual.
So you're talking about how turnover, that she's going to have 2 units there, and you think that that's going to cause a problem? Is that what I'm hearing correctly?
Yes, yeah, and not just our corner, but it's kind of a small little B-shaped area. It might just be ineffective public trash works, but whenever, I mean, there is hardly ever a period of time where there's not trash outside of rental high turnover areas. And I would just hate to see that happen to this particular piece of property. And again, the graveling and the, I mean, it's a beautiful piece of land, I would argue.
Okay. Go ahead, Mr.
I have 2 questions.
Yes, sir.
Your home, what type of structure is it?
It is a brick single-family residence.
And you've mentioned trash in the neighborhood.
Yes, sir.
Have you found any trash on that lot they're talking about?
That lot is primarily overgrown and with wildlife. And I believe from the road you can tell that there is a concrete slab, but it's mostly plant life and animal life and
So
growth.
no trash?
There's no one residing there. No, well, actually, I would say in the past few weeks, there's been a shopping cart that's been abandoned outside of there for quite a while, but
Okay, thank you.
yes, sir.
Yes, Mr. Snow.
You mentioned several issues. One, I thought you started off by the number of residents and cars that, I thought that's where you were going with your comments. What is your major concern? Is it about the number of potential residents in the 2 homes? Or is the environmental and the litter issue paramount?
I would argue that they go hand in hand, that the higher the volume of individual residents, the more likelihood there is for trash. Also, a lot of the people on our corner own and reside within those homes, and so I think there's a greater amount of care that goes into the upkeep of the properties. And so if you're renting out to manufactured homes to anywhere from 2 to 12 people, and especially not being present on the property, that it's really difficult to police that sort of behavior.
Okay, thank you.
Absolutely.
Mr. Marchant.
Related to that question, Are there other units in your neighborhood that are rental properties that you're aware of?
Yes, sir.
Okay. Can I ask a question to staff while she's?
Yeah.
So this is an R4, this is zoned R4. If we have two manufactured homes, what is the density of people for that? Is it two family units? How does that work?
So we would consider, you're allowed to have a manufactured home as an ADU. Any over 3 would not be allowed.
Any persons over 3?
Any if they were asking for manufactured home, 3, we wouldn't allow that. But one of these would be the ADU.
But because it's an R4, you can't rent rooms out to multiple people. This is like, you'd rent one manufactured home to one tenant, right? Which could be a family unit, correct?
I mean, we don't.
In other words, you can't
like,
multifamily
permit-
this as we're.
I see what you're saying, like
Yeah.
split up one home
Correct.
into, no, you're correct, yes. I understand.
I'm trying to sort of calm her
Yeah.
concern for
Yeah.
12 adults.
We can't
and-
control how big the family is or how big, if it's roommates or something like that.
Yeah.
But we would require that each unit have 2 parking, so 4 parking spaces is required by the ordinance.
Thank you.
Yeah.
May I ask a question of that?
Hold on. Do we have any other questions on that side? I'm sorry, you had a question.
Yeah, I'm curious, I'm not super familiar with that legislation. How, say I were to rent the home as a single family and I work in food service per se, rent is very expensive. I choose to rent, it's a 3-bedroom, I have a boyfriend, I rent to 2 of my girlfriends and their boyfriends. How does this stop that? I mean, how is this something, I mean, rent is very expensive, and so if you find something affordable with, I'm just curious how this would put a stop to
So
that.
we don't have jurisdiction over that.
Yeah, that's beyond the board, so I'm going to advise the board not to attempt to answer that question.
We don't have jurisdiction over that.
Then for the record, that was my meaning by multifamily, is multiple adults in that same shared space.
Thank you so very much for your testimony today. We had someone else over there who was speaking in opposition.
Was he signed? Was he sworn in?
So were you sworn in as well, sir?
No, I wasn't. I got here later. I swear.
You want to be sworn in as well?
Yes, sir, because I didn't sign that, but I would like to make comments.
All right, if we have anyone else that think they might want to speak tonight, if you would, please stand up at this time and let's administer the oath to be sworn in. Please, anybody else that may want to speak that has not been sworn in. Thank you. Please state your name and address for the record, sir.
My name's Timothy Baker. I live at 1743 West Avalon Circle, right next door to this lot.
106 or 110?
106.
Yes, sir.
You know, my only concern with it is, you know, as the girl that spoke just now, there is a lot of trash in front of that lot often, and I have to pick it up. That lot has been cut one time since I've been there in 7 years. I have tried to cut the front of it because it kind of comes right up into my fence and everything and got eaten up with poison ivy. Another concern of mine as a retired builder is that that grand tree sits right up in the front corner by my lot. Therefore, and also the fact that when I remodeled my home, I was told by Charleston County that I was in a flood zone. And so therefore, you know, I'm assuming this is also in a flood zone because the American Legion backs up to the back of me. And they just tore down their building and they rebuilt and had to build it way up in the air. Okay, I built an 8-foot privacy fence behind my house, and then the American Legion built this building way up above my privacy fence. With this grand tree up in that front corner of I didn't know it was 2 lots, you know, because when I met the owners years ago, the one time that it was clean, she had told me that she thought she was going to build a house in the back of it for a friend of hers to rent. And I thought, oh, that'd be cool, you know, get some of this stuff cut down and everything, because we also get snakes in our yard from that lot, and raccoons and so forth. But what my concern was with this grand tree and the fact that we're in a flood zone, that grand, and the fact that it's now 2 lots, I only thought it was 1 lot. If it's 2 lots, well, then that means that one of these manufactured homes is going to have to be way up in the air, right up by my fence. And my wife has spent a lot of money and a lot of time making a beautiful garden in her backyard. That whole side of my house is nothing but glass so that we can watch the birds because we've got multiple bird feeders out there. But now we're contemplating putting our house on the market because we don't want a big mobile home towering over our house, looking in the side windows of our house and in our backyard. You know, the grocery cart that she spoke about has been there for probably a week or so. You know, like I said, trash is always there. People just fling beer cans. And as far as the multifamily thing.
So that's your time. Your time kind of slipped away on you.
Well, can I say one thing about the multifamily thing? There was crime in the area because of the multifamily, and apparently whoever lived in one of those units that was breaking into everybody's cars moved out. And so we don't really want, multifamily.
Well, hold on. Let me see if anyone here has a question. Mr. Williams?
Yes, sir. So, question about that. Was there previously a multifamily home there or a manufactured home there?
There was a manufactured home there on the other side, which would be, I guess, the other lot. Like I said, I never thought that it was 2 lots. In fact, we were contemplating offering to buy the lot, but then a realtor in the area said, well, they want way too much for that lot, And so, we backed off of that and we bought a piece of property in Orangeburg. Which is just a farm, but
okay.
I just mainly we don't want a mobile home towering over our house, looking into our window.
I understand. Do we have any other board member with a question? Thank you so very much for coming out tonight for your testimony, sir. Thank you. Do we have anyone else to speak in opposition for this case?
My name is Don Hudson. I live at 1723 West Avalon Circle. I also own 1725 and 1727. On the map, it's 1112, 113, and 114. So we're very close to the location that we're talking about here. When I saw this first come up, I was excited because when I saw that, I was thinking a manufactured home was one that was assembled, brought on site, and put in place like a residential home like we have in the neighborhood. When I presented my comments to the BZA, we had mentioned that there's been 4 new houses placed on West Avalon Circle alone, and then another 2 on East Avalon Circle. And then within that area there's been a number of houses that have been renovated. So this area is being revitalized, and we're trying to get it up to par. And so when I read through the instructions that they had and where they were talking about putting 2 mobile homes, that was my opposition to it, was that we'd love to see a residential home go there or 2 residential homes placed on the lot. It's a family neighborhood. Like I said, it's becoming revitalized, and just wasn't appealed to the thought of having 2 mobile homes. So that was my only opposition.
Okay. Does any board member have a question? Yes, sir.
You mentioned that the neighborhood has been revitalized.
It is, yes, sir.
And this lady, what she's proposing, I assume, is to clean up and put something livable there.
Yeah.
So you don't consider that part of revitalization?
Oh, that's why I was excited when I saw it. When I see manufactured housing, I was thinking, something that was pre-assembled, off-site, and brought on site and put down per code requirements, like the R4 that I thought was designated for this neighborhood. Because the new houses that have been put in there have been all new structural built houses.
So you don't think this would be an improvement from what's already there?
It's a vacant lot, so yeah, it would probably be an improvement, but not a residential house like the majority of the neighborhood is.
Thank you.
Anyone else? Anyone else? Thank you so very much for your testimony tonight, sir. Do we have anyone else to speak in opposition? Yes, ma'am.
Good evening. My name is Gail Millage. I live at 1542 North Avalon Circle. Been there since 2002. 98 and 97. We're next to the existing mobile home that's been spoken of tonight. This neighborhood has two grandfathered mobile homes. I sent in my notes, so this is not new to anyone who's read them. We have two special exception mobile homes in the neighborhood. Both of those are behind existing single-family homes. So they're renting them out to their family members, or also possibly not to their family members, but they were on existing driveways, existing situations, and they're also a little hidden, so they don't quite look as trashy as mobile homes can. So I don't believe the neighborhood needs any more mobile homes. My main point, unfortunately, is with Ms. Kuhn. She lived in the neighborhood for years. She never did any improvements on her home. I understand a lack of money. We don't fault people for having a lack of money, but we do fault people for not keeping things tidy if they can. And she had no physical impairment. And then she just moved one day and left the mobile home. And it sat, and it sat, and it sat, and the windows broke, and the door opened, and people came in and out, and animals came in and out, and it was a hazardous condition in the neighborhood. She was non-responsive, and the county finally had to make her take it down. And that, to me, speaks volumes.
Ma'am, please, no outbursts.
It actually is true, because I'm the one who reached out to the county.
Can you
but we
please
won't.
direct
Yes,
your
sir.
statements to the board?
Moving on.
And no personal attacks, please?
Absolutely not.
Thank you.
No, absolutely not. This
Thank
is
you.
strictly. So she does not care for her property. This is property. We care for our property in this neighborhood. Those of us who own the property care for our property. We care for our property values, but we also love living there. We have marshland. It's quiet. No one bothers us. We like this neighborhood. It's mixed. We like the mix. I like low income and a little higher income together. But as has been pointed out, this neighborhood is up and coming. It's not fancy up and coming, but it's up and coming for young families and people who want to buy a little piece of Charleston. And it's very exciting. It's really wonderful to see over the last 20 years that I've been there. 2 mobile homes is not going to increase. It's not going to help our property. I went around the block and counted. We have 77 apartments and or duplexes plus rental homes in our very small neighborhood. If you walk up Orange Grove to Sam Rittenberg and go to the neighborhoods on either side, all the way up and down, we are the most dense, we have the most apartments, we have the most duplexes. We have very little parking, we have no on-street parking. Our roads have not been touched in 20 years. We're a combination of city-county, so we get a little forgotten. We don't want our neighborhood to be forgotten. We want our neighborhood to be lived in, healthy, and happy, and we want that tree to not be bothered.
Thank you for your time. For a moment, let's see if any board member has a question. Mr. Williams?
How you doing? Quick question. How many housing units are there in your neighborhood? How many housing units are there where you are?
Okay, well,
Your neighborhood?
duplex across the street. I mean, I went and counted just doors. So, and then there's an apartment down the street. There's a duplex down the street. So that's North Avalon Circle. East Avalon Circle has a duplex and a big apartment complex. So there's 2 big apartment complexes in East and North section. Then if you go down Jones Street, there's a set of, it's not duplexes, it's apartments, so there's 9 units there. Then on West Avalon Circle, apartment complex, big apartment complex, 20-unit apartment complex, and duplexes across the street. So it's a lot. It's a lot.
Mr. Jordan?
In regards to these words that the lady just said, can I ask staff a question?
Yes, please.
So if this is approved and the lady builds or does what she plans to do, does the county have any recourse after that if the property is not kept up?
Yeah, we do have a derelict mobile home ordinance, and that's in our Chapter 11 for violations.
So-
And this is, the manufactured home term was changed years ago. Used to be mobile home, trailer. What the other gentleman was speaking of is the modular home, which are brought on site, but we consider modular homes site-built.
So would that mean if it was let go and the neighbors want something done about it, they could come to you?
Yes,
County, I mean.
if it doesn't comply with that section, the derelict mobile homes.
Which includes keeping it clean? Thank you.
Any other board member?
Just a question of staff. One person mentioned that, I guess, the business that build elevated, was that a requirement, or did they just happen to do that? I'm just wondering if she has to elevate these mobile homes, that it might be above his fence level, I guess is my question.
Let me double check. Okay. Yeah, it's AE 10, so that is a flood zone. So it would have to meet AE 10 requirements.
Does that answer your question, Ms. Smalls?
Yes.
Okay. Do we have another question on that side? Am I right? Thank you so very much for your testimony tonight. Do we have anyone else to speak in opposition? Do we have anyone else to speak in opposition for this case? Yes, please, sir. Please make sure you state your name and address for the record. You're limited to 2 minutes, please, sir.
My name is Edward Meyer. I live at 1542 North Avalon Circle. That was my wife, Gail, talking before. This piece of property has, honestly, I wanted to do an extension on the back of my house. I wanted to put a bedroom up. I know I have 2 minutes. So there's a big oak tree behind me, and it's got a telephone pole that lives inside the tree. The county came out and told me that I couldn't build my extension because this was a grand tree, and I couldn't build under the grand tree or inside of its root system. This grand tree on this piece of property, on one of the hand-drawn things of the property line, this tree extends all the way across the property. If you brought something in there, I don't know how you would put a sewer line, I don't know how you'd put an electrical anything without having to grade it, and she's talking about doing it as a gravel. You'd have to grade that thing. I think if nothing else, an arborist, the county, whatever they have to do, has to look at this piece of property before they say that it's okay to do it. This neighborhood had a lot of really nice trees, and it's been there for a long time. The neighborhood's been a long time. I think that was my timer.
Okay, hold on. Yeah, well, you did good. Let's see if anyone has a question. Mr. Marchant.
Thank you, Mr. Chairman. I appreciate your testimony, and I appreciate your comment. And so this question isn't for you, but it's for staff because of your testimony. I'm assuming that any applicable permits, including additional variances, would have to be requested before the placement of two structures, correct?
Yes.
I mean, right now, we're just approving the use.
Right, correct.
Not any kind of site plan review or anything like that.
Correct.
Which could be a challenge.
Correct.
Okay,
And
thank
we
you.
have been conversing, we have two arborists on staff, Sally Brooks and Kyle Foster. Sorry, that's the timer. You have more time. But anywho, yeah, so you want to talk about it a little bit more, Sal?
Yeah, I was going to propose that if you do approve the application, that you add a condition that the applicant will meet with staff arborist on site to review any encroachments, or I guess in looking at the street view and the site plan, there's a little bit of concern about any trimming that might be required in order to bring a mobile home into the site, since there's one already there, and how to kind of get around that. So basically have the applicant contact the staff arborist to schedule a site visit to review any tree impacts prior to permitting the mobile home, something like that.
Will do. Go ahead, Mr.
Mr.
Martin.
Chairman, so related to that comment, and I know this isn't pertinent to what we're trying to do this evening, but setbacks, utilities, grading for driveways, gravel, et cetera, all that has to come through the county for site plan review and approval prior to anything being placed, including arborist work, tree work on anything like that. Is that correct?
Yeah, it doesn't go through like the site plan review. That's for everything that's not single-family residential, but it does go through a staff review at the front counter with our permit specialists. They handle all the single-family residential permitting and reviews, so.
Thank
yes.
you.
Mhm.
You have a question?
For the speaker, I have a question to staff.
Yes,
I'm gonna
please.
ask.
Go ahead.
It's not related to the tree. Is that all right?
Yes, sir, please.
In this flood zone, what is the elevation required off grade for, I'm trying to envision a mobile home.
So I think, Sally, in the AE 10 would
10
be elevated
feet?
11 feet?
11
12?
feet?
Is that right?
So the
Oh,
county building requires 2 feet above.
Yeah, 12.
So it would the finished floor would have to be at 12 feet, but that doesn't mean the house is 12 feet in the air. That you subtract the grade, the existing grade level there. So we would need a elevation certificate from a surveyor to determine the grade level. So say the ground level is at elevation 10 or 9 or something like that, might be realistic for that area. Then if the finished floor is at 12 feet, that means if the ground is 10, that there's a 2 feet elevation of the house. So, yeah. So without knowing the exact grade, I can't tell you exactly how much they'll have to put it up in the air, but yeah, that's the idea behind that.
Good question, sir. Do we have any other questions on this side? Thank you, Ms. Brooks. I appreciate that. And thank you for your testimony tonight. We appreciate you bringing that to our attention, so we'll get.
I'd also like to point out just the way that the road turns there. There's no sidewalk. There's no place for pedestrians. And it's already, I've lived in this, I've lived 2 spaces down from that corner for 20-something years. So often do you meet another car coming around. I mean, it's a small neighborhood, but still, it's like.
No sidewalks.
There's a lot of this kind of stuff. And so to have, I don't know where she would park, I don't know, even just entering the roadway is kind of weird. I mean, and for one person to live there, okay. But if you have 4 cars in a space like that, there is no space for it.
Thank you for that observation, sir. Yes. Thank you. Do we have anyone else to speak in opposition to this application? Okay, the young lady back there. Thank you. Good evening. Please state your name and address for the record.
My name's Megan Plunkett. I live at 1543 North Avalon Circle. I think it's 123. I'm the yellow one right next to 121. One off. A lot of the things people have said tonight, I absolutely agree with. A couple of things I haven't heard a lot about that are concerning for me are safety. That corner is a corner where every commercial vehicle honks at least 2 or 3 times before they go around because they take it at a high rate of speed. Residential takes it at a high rate of speed. I almost got hit coming to the meeting tonight, just pulling out of my driveway because somebody came around the corner so fast. If you put 2 homes on that single lot, parking, again, no street parking, there's not room. There's barely room for 2 cars to pass in our neighborhood. So if you put a car on the side of the road, you're greatly restricting any traffic flow. Also, if children move in, where do they play if it's all covered in gravel? They're now in the middle of the street, safety for pedestrians as well as vehicles. But in addition to that, things like drainage. The house that was built at 244 was built since I moved in. And my backyard now floods more than it did before that house was built. So looking at all the properties around it and how that affects all of us, that's another concern of mine, is just what that ripple effect is with all of the different drainage, the streets, the safety, things like that, how that impacts it. So that, in respect for time, that's the quick version of my thoughts.
Well, you did well. You did well. Let's see if any other board member have a question for you. Does any board member have a question for this young lady? No? Okay. Thank you so very much for your testimony tonight. All right. I don't see any more hands. Anybody else in opposition? Very good. Ma'am, at this time, you have the ability to rebuke anything that they said. You're limited to 2 minutes with this.
Okay. I just wanted to say that when I took that trailer down, I took it down. It was not forced by anybody to take it down. And as I had said earlier, that this was an eyesore, they also agreed with me. So we had that in agreements. As far as not being able to pass two people on the same road, our road is very adequate to drive two vehicles going down. And my lot is big enough to hold the parking. And I will not do anything to the tree. That's the reason I bought the property in the first place. That's all I have.
Okay, let's see if anybody has a question. Mr. Williams has a question
Yes,
for us.
ma'am. And I was wondering about this earlier. So you had how long ago did you have your mobile home there previously?
So
on that property?
So that mobile home was there since '66,
And how long have you had this property?
and I've owned this property since 2000.
So how long was the mobile home on there when you had it?
And then the mobile home that I tore down, which was the one from 66, I tore that one down, and I haven't put anything up in its place. And I believe that I took that mobile home down 2015, but don't quote me, please. It's right there on the paperwork. I'm sorry, I was not.
I'm just trying to get the timeline a little bit better understood.
Say again?
I'm just trying to understand this timeline,
Yes.
because from hearing what these other residents have been saying.
Oh, well, as far as it only being mowed one time in 7 years, my father and I have been there several times in 7 years, but that's okay. I understand they have to see it every single day, and so I am ashamed, but I want to make it better now, and I can. I have the opportunity to do so.
One last question, ma'am.
Yes.
Are you intending to live there at any point or rent it solely?
And then eventually, that's where I'm going to retire, yes, because of that oak tree. That's the reason I bought the property in the first place. But yes, I want to retire there, and the reason why I want to is because my dad is going to need a place to live as well.
All right, thank you.
Thank you.
Hold one moment. It's okay.
Excuse me.
Mr. Jordan has a question for you. I'm going to get to you too, gentlemen.
If you get to carry out your plans, will there be room there for kids to play in the yard?
Absolutely. Absolutely.
Thank you.
And if gravel is not the best way, I just thought that would be it would be nice and clean and everything. But if that's not the best way to do it, I mean, I love grass too. It just got away from me, that's all. It was a piece of property and I moved and it got away from me, and life happened. And I am sorry about that.
We have another question for you.
Yeah,
Yes, sir.
I'm not sure I understood. You bought the property in 2001?
I bought the property in 2000, yes.
2000, and you removed the trailer in what year?
I believe it was 2015, but don't quote me.
Okay, thank you.
I just want to thank you, Mr. Chairman. I just want to confirm that there was only one trailer on the property. There's never been two trailers on the property.
There has been a trailer and then a shed.
And we're trying, and the reason we're here is because they're trying to put two trailers.
No, I'm glad you brought that up. So even if it was just one, it'd still need a special exception because that that percentage is way under the 25%.
Oh, because we're under the
So,
25%.
However, if you did want to just approve one, you could do that.
Right. But it's because of the 25% rule is why we're
Yeah,
here.
even if they just came in with one, it would still have to come to you.
No problem.
So it's
That's all
up to
I-
you whether you not want to approve
Right.
one or two.
No, I understand now. Thank you, Mr. Chair.
You gave him some ammunition. Okay.
Ms. Forking, along those lines, you mentioned earlier that the second trailer is considered an ADU, correct? And so we would basically just be saying that a second trailer could not be an ADU, but they would still be allowed some other form of an ADU back there, right?
That could probably work, depending on the tree situation and everything, parking and.
Ms. Smalls?
Yeah.
I just wanted to ask the owner of the property, are there utilities there for two trailers? And also, are these brand-new trailers that you're purchasing, or are these used?
They're,
mobile
no,
homes?
they're not used. They're brand new from Clayton Homes, and they are single wides, but they are state of the art. And it was going to be this year's, so 2023 would be the year of them, and they are properly zoned to for us.
And you're aware of the other requirements? You understand that they have to be skirted?
Skirted in, yes, I do. They have made that aware to me.
Mr. Trueslow, you had a question, sir? No. Okay. Okay, Mr. Jordan?
Can you give us your thoughts on this gentleman's concern that if you put there what you intend to do as it is required, that it would be looking down on his windows and his yard?
Well, I've already surveyed the lot, and it's only going to have to come up 2 feet.
But what did the staff say about that? How high has it got to go?
Yeah, what Sally said is we would need that flood.
And I have it. As far as putting it up, it's not the whole manufactured home right up against his fence. It would be one room, if anything, it would be one room at the end of the manufactured home. Because as you saw on the diagram, it's going to be facing the oak tree, as the other one, like an L shape, is facing the oak tree as well.
Do we have any other questions? Board members, do we have any other questions? So thank you so very much for your testimony tonight.
Thank you, y'all.
Okay. At this time, this case is closed to the public. Board members, do we have any discussion, any questions of staff? I see your hand.
No,
on.
I'm going to try to take a stab at a motion if we don't have any discussion, but I don't know if I'll get support.
We could have a motion then discussion.
All right. Hey, just throwing it all out there. It seems like everybody's biting at the bits to get at it. All right, so I need a motion to either approve or deny this particular case.
All right,
Yes, sir.
I'll start. Mr. Chair, not sure if I'll get the support for it, but I'm going to move that for item BZA 0623000681, that we deny the motion for the variance. I will support that with my denial with it does not meet the criteria for number 4. I believe the authorization of a variance will greatly be a detriment to the adjacent property, the public good, and the character of the zoning district, and it could be harmed by granting this variance. I also have a safety concern. I don't believe putting additional units on this property or allowing properties on this access to this drive on a curve. We've heard testimony about access. I just don't think it's a great place for this. So I don't know if I'll get a second or not, but I just don't believe it works. Second.
My concern was 2 mobile homes on this lot.
So we have a motion that I believe was made to deny, and did I get a second down there, Ms. Switzer Smalls?
2 seconds.
I got 2 seconds. Okay, I guess I get the chance to pick. All right. Any
Mr.
discussion?
Chairman, discussion, yeah. Can you just clarify again, which criteria again? I'm sorry.
I believe it's criteria number 4.
You're looking at variance criteria. It's special exception. I just, yeah. No, you're okay.
I'm coming.
Number 2.
2, okay.
number 2, it's not compatible with the existing uses in the vicinity and will adversely affect the general welfare and character of the immediate community.
Thank you.
Mr. Jordan, you had a comment?
Does this lady have any recourse to where she wanted to change her proposal from 1 trailer to 2, or is it just all or nothing?
Yeah, I mean, if the plan changes enough, we could bring it back as a different request. It would be a new application. We'd have to make that determination. If not, she would have a 1-year waiting period, or
Does
she
she
could
understand all that?
appeal. I mean, we
She'll
could
get
certainly
that.
talk to her tomorrow and clear up any questions she might have.
Thank you.
Mr. Neal, is your concern there being 2 trailers there, or the fact that there's a trailer there, period?
It's more on, that's a very fair question. I heard testimony tonight that said there were no other trailers out there other than the ones behind houses. So that there were houses out there, and then there were ADUs or something in the back. The character of the community was residential back there. And it just, to me, when you start adding the rest of the factors, there's trees out there, we've got flood elevation. Obviously this is a hard lot to develop. There's a grand oak tree that's out there. It's going to take staff a lot of stuff. I just don't have enough stuff in front of me to say, yes, let's just go hard and then dump it on staff to let them figure out what to do. So I just think this plan in front of us that could do other things is too much for me to swallow. I hope that they can come back. I think it's a great community, and you could put 1 unit on there. And if they can figure out how to do an attachment, an ADU, something, I'll support it. But this plan that has too many red flags to me that are up in the air, I just can't support.
I guess my concern with that position really lies more in the fact that what we're being asked to consider is whether or not a mobile home can go there simply because there's not, the neighborhood doesn't have, 25%
right.
Of the units within the neighborhood being mobile homes. But there are some around the corner. You can look at Google Street View and go around the corner and actually see a mobile home within 300 feet. I do have a problem with limiting a property owner or a property that had a mobile home on it before, and it was in that condition when they purchased it, and they're willing to make improvements. I could support limiting it to 1 mobile unit at this time and letting them figure out the whole ADU portion later. But I think it would be a little stringent for the board to go as far as not allowing any mobile homes on the lot. Because either way, the property can be developed. And however it's developed, if it's a stick-built home, it still has to meet all of the criteria. They still have to avoid the grand trees or get a variance for it. They still have to meet the flood criteria. I think we're picking a little too hard at this just being a mobile home. That's my opinion.
Mr. Jordan, go ahead.
Does the staff know the trailer she tore down when it was put there? Because somebody must have approved it to be there, because it was there.
Well, they said she made a point that was done back in 1966, so that's quite an old trailer.
But somebody allowed it to be there.
Yeah.
Yeah, we had the demo permit in 2018.
But my point is, there's been a trailer there and it fit. Because I don't have no idea how big the trailer was.
Yeah, I kind of agree with Mr. Nelson. I don't think we should not allow this person to put 1 dwelling there. 2, possibly. No, but 1 definitely. To get 1 unit in there would be fair for her to live in.
Yeah, I could support 1, but not 2.
Okay. So do we have any more discussion before we bring this to a vote?
Would you restate the motion, please?
Well, I just want to ask a point of reference on the procedure here. I mean, my motion for
it's still up.
Denial doesn't pass, then a motion can be made to move forward with one with restrictive conditions, right?
Yes.
Yeah.
Or you can rescind your motion.
I'll stick with the original motion. If it doesn't pass, then we can move on. But this one is for to deny this variant, this special exception based on our criteria 2.
Okay. Any more comments?
If I could say real quick, with Mr. Nelson, I agree with you because I don't think it's incompatible with the existing area. It's just going on precedent from this board, I agree with you. So.
Anyone else? Okay, so we have that motion that's been seconded. So we need to bring it to vote. All those in favor of denying this case, please indicate by saying aye and raising your right hand.
All right. Well, no, sorry. Say it again. Say it one more time.
Motion to deny.
To deny this case.
The motion is to deny the applicant.
So we have 1, 2, and 3. All right, those opposed? Okay, so it's open, it doesn't pass. Okay, so we need a motion to either approve or deny.
All right, Mr. Chair, I'll make a motion. In the matter of BZA 0623000681, I'll make a motion that we approve the request with some conditions to follow. In doing so, I find that it does meet all 6 criterion required for the request. That one is consistent with the Charleston County Comprehensive Plan and the character of the underlying zoning district would not be harmed. I am particularly moved by the housing element component of this, an affordable housing element component, and I say that as a father of a 24-year-old who's struggling to find housing in this town as well. Criterion 2, that it is compatible with the existing uses in the vicinity and will not adversely affect the general welfare and character of the community. I believe that special conditions we'll put on here will help alleviate some of the concerns of the neighborhood. For criterion 3, that adequate provisions will be made for such items as setback, buffering, fencing. The applicant will have to adhere to all of the other setbacks required as they go through the process of getting a permit for the manufactured home, so we'll meet that criterion. For criterion 4, that where applicable, it will be developed in a way that will preserve and incorporate any important natural features. Again, recognizing that there's a grand tree on the lot, the applicant has testified that that was a motivating factor for purchasing the lot, and I believe that she will do everything in her power to keep that grand tree as intact as possible. For criterion 5, that it complies with all applicable rules, regulations, laws, and standards of the ordinance, including but not limited to any use conditions, zoning district standards, or site plan review requirements. And again, she will have to go through the permitting process to install the mobile home at the location anyway. And 6, that vehicular traffic and pedestrian movement on adjacent roads shall not be hindered or endangered. And given the fact that a residential unit could be built there either way, I do not believe that that putting a mobile home there will have any more impact on pedestrian movement or cars as a stick-built home. So in making my motion, I do want to adopt the special condition recommended by county that the manufactured home shall comply with section 6.4.24B of the Charleston County Zoning and Land Development Regulations Ordinance, and I would like to add a special condition that no more than one manufactured home be constructed on the property. But that will not preclude any other ADU uses on the property.
Will you also include the condition that was recommended by Sally, that they meet with the staff arborist as well?
And include the condition that a staff arborist or certified arborist be present for the process.
Do we have a second?
Second.
Okay, we have a motion that's been properly moved. Right. So, choose all.
I didn't get that one.
Thank you for catching that, Ms. Clark. Any discussion? Question? All those in favor, please indicate by saying aye and raising your right hand. Aye. Any opposed? Okay.
Can we keep those hands up who actually are just going to?
For the ayes?
For the ayes?
Yes.
For the ayes.
No.
Okay. And the 2 that oppose, please? Very good. That carries. Congratulations. Your application has been approved with conditions. Please make sure you meet with staff so that you can have the right instructions moving forward. Okay? Very good. And thank you for all the participation. All right.
They'll let them know. They'll let them know, because that's the condition.
So,
Those are the
our next case tonight. will be done by Ms. Working. Ms. Working,
Yes.
we have 2 cases left. I would love to combine both of these.
Yes. I plan to attempt to do that.
Okay.
Of course, I still have the timers at 5 and 2, but if we need to increase it for it being 2 cases, that's up to y'all.
I'm looking at the volume of this crowd. I think we can do so.
Okay.
Not knowing about one soul, but let's try it.
Okay. So the first case is BZA 0623000683. The applicant is Thomas W. Kellum, III of Kellum Engineering LLC, and the property owner is D.E. Palalis of Paulus Holdings LLC. They are requesting a variance to remove 2 grand trees, and that's for a proposed hotel at 1938, 1948, 1958, and 1964 Savannah Highway. And those are tax map numbers 351, 1300, 055, and then ending in 058 and ending in 059 in the St. Andrews area of Charleston County. The 3 properties combined are 10.25 acres and have frontage on Savannah Highway, Orleans Road, and DuPont Road. The subject properties are located in the DuPont-Wapu Area Overlay Community Commercial CC zoning district, and that's the district that's shown in red on the map. The proposed project is a 210-room hotel with convention center and rooftop restaurant. It is currently in the site plan review process. On the site plan, the 2 grand trees are shown in blue, and that's a 55-inch DBH live oak and a 29-inch DBH red oak, totaling 84 inches total. And please note that you can, each tree may be considered separately for approval conditions or denial. The next variance request after this one is related to architectural standards. This is the applicable section of Zeldar for the trees. The overlay map, and the aerial photographs. And this is one of the trees in question, the 55 DBH Grand Live Oak. We visited the site on June 22nd, but the grand tree inspection was done on May 12th, 2023. And this is a picture of the 29-inch grand red oak tree, and a couple of pictures of the existing conditions on the subject property, Orleans Road, DuPont, and Savannah Highway. This is the existing conditions plan, and then the site plan, this is another existing conditions plan showing the trees, and then the site plan of the proposed hotel here. And plats. There's 2. For this case, we stated that it may meet all 7 criteria. And again, you may approve conditions or deny the request based on the 7 criteria. If you do choose to approve, we have 2 suggested conditions. One is prior to zoning permit approval, the applicant shall complete the site plan review process. 2, the applicant shall mitigate the removal of the 84 inches DBH trees by either A, submitting a mitigation plan for review and approval, indicating the installation of canopy trees no smaller than 2 1/2 inches in caliber, equaling inch per inch replacement. B, by depositing funds into the Charleston County Tree Fund as described in section 926 of Charleston County zoning ordinance. Or C, a combination of both A and B. The allotted mitigation shall be in place prior to removal. If you're okay, I'll present the next case.
Go ahead, please.
Okay. And of course, it's the same applicant, property owner, and properties. But this request is from the design standards and architectural design guidelines for the proposed hotel. More specifically, the applicant asking a variance to exceed the maximum building height of 7 stories, to waive the requirement that windows shall be inset with sills, and to waive the requirement that single large building masses shall be avoided for a proposed hotel. This is the ordinance sections in Chapter 9 for the design standards. Let's see what else. we stated that it may meet all 7 criteria. So they provided floor plans. As you can see, the 2nd floor and we can go back to these if needed later. Restaurant plan. This is the elevation, windows bump out, elevation back and right, and the elevation front and right side, and then a rendering of the hotel. And again, we said that they may meet all 7. If you choose to approve this request, we just have the one condition that prior to zoning permit approval, the applicant shall complete the site plan review process. And if you do have questions, both Sally and I will try to answer them together.
I'm gonna come to you last because you always get the chance to jump in first. Let me come to this
No
side
problem.
over
I
here
go in
first.
whatever.
You guys get my eye because I'm looking that way all the time.
I'm last.
Any questions on this side first?
All right, Mrs. Working, that I'm sure we'll have an opportunity to ask the applicant some of these questions as well. But the applicant has stated that the project has broad support from the community and the West Ashley Revitalization Commission. Have you had any conversation with the city, with the community at large, or with any members of that?
I have
committee?
not personally, and I haven't seen documentation of that, but I have heard that from other staff and from the applicant. And we also did not get any letters of objection from the city or from the surrounding property owners.
Okay.
That's the best I can answer that.
And one other question, just related to this whole mezzanine floor.
Yeah.
Does the county have any position on whether or not a mezzanine constitutes a floor?
Okay.
And it violates the...
Sally's going to take a shot at that one.
Okay. I guess the simplest thing I could go with is if you look on sheet A201 and you count the spaces between the floors. If you start at level 1 and you count all the way up to the base of the roof, you're going to count 9 spaces there.
Gotcha.
So that's
I'll be
where
curious
we're
to,
coming up with that number.
I'll be curious to hear what our resident architect has to say about that.
That's fine. That's fine. Yeah.
We are too.
Anyway.
That answers your question.
Yes, thank you.
Anything on this side?
I'm quite familiar with that corner. I'm just wondering, the height of the building concerns me.
Okay.
I can't think of anything else that's that tall in the most immediate area except over closer to Citadel Mall where the, they have those taller high-rise office buildings, but it'd be nice to see that corner revitalized. I'm just not sure about the height.
Mr. Marchant? Yes, sir.
Thank you, Mr. Chairman. Ms. Working, you mentioned on both cases that they may meet criteria 1 through 7 for all 7. I guess my biggest question, and this is related to the 55-inch tree and maybe some of the architectural requests, is how does it meet 3 and how does it meet 6? And the applicant perhaps can prepare for that response as well. As it relates to the tree, how many site plans have you seen that show various parking and drainage options? Or is this the only one you've seen?
Did you review that? Because Jennifer Stiles reviewed the original. I'm sure this is not the very first one.
This has been the basic layout through the initial submittal, as far as I understand.
If I'm reading the plans right, the highest part of the site, natural, if you call it natural, I know it's parking lot, is where the retention is recommended to be, which means digging out more, which is why we have to remove the tree. That's my understanding. But it seems like water mitigation, and we have some resident engineers around here that might be able to comment better, could be handled differently. So the reason I ask is number 3, I think specifically, is 3 or 6 owner?
Yeah.
Sorry.
So I think our opinion was that it would unreasonably restrict, but not prohibit.
Hmm.
So, because it says or unreasonably. So we, yeah.
It's more for the applicant. There are other creative solutions to parking and water retention that
Of course.
could happen on this site.
Yes. Yeah.
Okay.
And if Jennifer Stiles was here, I'm sure she would tell you it doesn't meet 3.
I think, looking with the plan grading wise, there might be some potential to shift things more easily around the live oak, tree number 2B, sort of toward the front of the property. There's a considerable, probably some grading and fill in order to make the drainage work. The red oak, that would be very difficult, I think, other than some sort of tree well or something, which I don't necessarily recommend in general, for that to work.
5-inch could be an amenity as much as, it's a pretty sweet tree. So, thank you.
All right, sir.
My questions are really just on the trees. I'm not getting into the architectural stuff. I have some concerns, as my fellow commissioner does, with the height, so I'm waiting to hear from the applicant. But the trees, do we have a grade on these trees? The plan is to remove both, they're asking to remove both of these trees, correct?
Healthy trees.
So one's 55, and what's the other one?
58.
29.
It's the red oak, not a lot.
29.
29. So the 55, do we have a grade on the 55? Because it looks pretty healthy.
I graded it as a B on the May 12th. Both trees.
I'm giving warning to the group. I'm having a hard time of finding why we need to take that out if there's some other options. So I'll leave that as my question open for the discussion from the applicant. Thank you, Mr. Chair.
Thank you. Anyone else? Mr. Jordan? Mr. Williams?
I have a question for staff. So as far as number 3, utilization of the property, they want to put a big hotel over here, a large hotel. Is there other utilizations for this property potentially?
Yeah, CC is one of our most accommodating for any type of commercial.
Right, so they can do other commercials,
Yeah.
commercial properties there. Okay, thank you.
And just for the applicant, when he comes up, there's a lot of traffic in that neck of the wood. That's not their issue, that's really the city issue. But I'm also concerned about that.
I believe a traffic study was required as part of site plan review. Is that correct, Sally? If you know, do you know? The traffic study?
I would have to look that up.
We don't know off the top of our head.
It seems like it would be, but I'm not 100% sure for that. Sorry.
Anyone else? Ms. Working, anything else? All right. Thank you.
I guess if you can just tell me kind of like what you guys want up on the screen.
Yeah. All right, come on down. So we're going to give you, since you have 2 cases that are up, we're going to give you just a little bit more time.
All right.
Don't take advantage of it.
Yes, sir.
And we want to try to get through this as fairly and quickly as possible.
Understood.
Okay.
I'm the civil engineer on the project, Thomas Kellum with Kellum Engineering, 634 Marina Drive, Charleston, South Carolina. And then we have Mike Remesey with R4. He's the architect, can speak to the architectural variances. I guess to touch on traffic, a traffic study has been completed. We're working with Charleston County on the improvements on DuPont and 17 there. Mr. Palacios has kindly worked with them to shift some buildings and make some improvements to that intersection. We're also working with the DOT to improve the traffic in this area. Obviously, there's going to be added traffic with the hotel, but very cognizant of what's going on. That's why the center entrance is where it's located. Potential improvements on both intersections, so we've kept that in mind. The 29-inch tree is located around elevation 8.5, 8.8, somewhere in there. It's just, there's upstream and downstream constraints from a drainage standpoint. This is within a special protection area. The site itself is almost 30% of the site's inundated during a 100-year storm event. That's no fault of our client. He's actually owns a town and country downstream out of his own pocket has made improvements, made drastic drainage improvements in this area. He's already committed to and made those improvements. One thing that isn't shown on this plan is there's approximately we've done a quick cost estimate, but so far $1.2 million in underground detention is going to be required. So it's not just these 3 ponds here. Every parking space on this project has underground detention under it, except for those that are pervious pavements. That kind of defeats the purpose there. So we're working with county stormwater staff to improve the drainage in this area. Also, it's in a AE8 flood zone. So basically, we would have to be at elevation 10. Mr. Palacios is looking for this to be a long-standing improvement to the community. So we're building up higher than that. We're bringing in additional fill. And with that, create some issues. Also, the tree ordinance changed a few months back, I guess maybe December, January, somewhere in there. So this 55-inch oak, the canopy on it is very small. It's been pruned quite a bit over the years. There's gravel running right up to it. There's parking in that area. We take that stormwater detention pond away, and there really isn't anywhere on site to replace it. There's a high water table. We're maximizing the underground detention as much as we can. But we've been through a few iterations of site plans. We've met with Charleston County Planning. We've also met with the City of Charleston. They've come into these pre-app meetings. We did go before West Ashley Revitalization Committee or Commission, unanimous support. We haven't heard anyone from the community come back with an opposition to this project. Mr. Palacios could speak to the history. He purchased it, I believe, in 2012, did his due diligence back then. Obviously, stormwater regulations have changed. Zoning has changed. There's a lot of things that have occurred in the last 11 years, but we're very cognizant of the area. We believe that we're meeting all the criteria, and we're going to make an improvement to the community. I'll be happy to answer any questions on the trees. I don't know if Mike wants to. Do you want to jump?
Just one at a time. Just
Okay,
one at a time.
perfect.
Let's see if anyone here that want to. Mr. Williams, I caught you at the corner of my eye.
Sir, yes, sir. I know you meet some of these criteria, but I'm having an issue with some of these other criteria, like number 3, as far as the conditions. Because of the conditions, the application of this ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. I guess my question is, does it have to be a large development like this hotel you're trying to do on this property?
Well, I mean, certainly anything could go there, but there is a restriction here that's not our fault, and that is the upstream development that has been allowed to occur over the last 20 years that doesn't have adequate stormwater management, and that is causing a detriment to this property. The same goes for downstream. Mr. Palacios has already made improvements there, but the upstream improvements without proper stormwater management is causing this property to be a detention pond. So a typical commercial development, you may use 15% of that property for stormwater management. In this case, we're already using 30%. Then we have to increase that. So it's not his fault, and it's not because of this development. It's because of things off-site out of our control that have occurred here where we have to make these stormwater improvements. So any development here is going to essentially require the removal of the 29-inch tree. Now the scale of this property or development here, which the goal I guess is for any development is to utilize the property. Max impervious coverage is 70%. We're at 65. So I mean we're not pushing the envelope, so to speak, with what we're proposing here.
So you want to use the property for something, but I'm having problems in kind of hearing the hardship here for using the property.
The hardship is the drainage, the off-site issues that have not, have come to fruition because of other developments that have been allowed over the years and the new requirements that have occurred since our client purchased the property.
Thank you.
Mr. Jordan?
But wouldn't you like to keep those trees there for your project if there was some way to do it?
The 29-inch tree cannot be saved. The 55, I'll be perfectly honest with you. I wish we would have provided a little bit more of the underground detention. We're working very closely with Charleston County MS4 and the City of Charleston MS4 for that matter to make sure that we're not causing any detriments with the drainage. But it is extensive, the amount of underground detention. Losing that pond is going to be a very big detriment to the project and to the watershed itself. And it's an unsightly tree, regardless of and I understand that may not factor in here, but this is a very expensive addition to the community, and that's the main entrance to the property. And the tree may have a decent canopy up top, but it's been pruned quite a bit over the last however many years it's been around. So it's not. I personally, as an engineer, do not see it as a benefit to the project. Thank you.
Yes, sir.
I'm hearing what you're saying about the underground retention and that this is basically the only scenario that you have for this layout. And I'm not trying to bring down the scale of this project, but I thought I heard you say that this was the only way it could work is losing that 55-inch tree because of the drainage retention. But it'll only work this way with a main entrance in that location. If there was another location of the main entrance, then that tree could be saved. So look, I'm all in favor of the revitalization. This whole area, Mr. Palacios has done incredible stuff out there. I have no problem with it. I'm just having a problem finding the hardship, like my fellow commissioners, of your plan causing this problem. Obviously, there's some drainage problems. I'm just wondering if there's another solution, if you can find it and come up with it, that maybe it turns down a little bit further. Maybe there's another driveway. Maybe there's another way to do something. That's where I'm trying to get to.
Understood. So the main entrance on 17 cannot move at all.
Why is that?
That is because of the driveway spacing. It's a DOT requirement. So in between Orleans and DuPont, we're barely meeting the requirements now. So that is the only option for a driveway location on Highway 17.
May I follow? There's not another access off Orleans?
There is an access there, and we can provide the traffic study if needed. But the access on Orleans has to be where it is to meet driveway spacing requirements as well. DuPont, we had a little bit more flexibility, but we could not have a main entrance to the property. We actually had an entrance closer to the coming in on the front of the hotel. The DOT required us to move that.
That you're having to do for the turn lanes and things like that off of 17 that you're dealing with South Carolina DOT?
Yes, sir. We haven't got very far into that right now. I don't know what's going to happen with the lights there. We're working with Charleston County on the improvements they're proposing at the intersection of DuPont and 17. So we shifted. That retail building shifted off of that corner. I believe 25 feet or so of right of way is going to be possibly paid for. We haven't got that far, but we adjusted our site plan to allow for those improvements there. One other point I think I'd like to make on the staff recommendations, if this does get approved, as far as mitigation being in place prior to the removal of the tree, I would ask that be changed, that language be changed to mitigation being in place prior to a CO. It'd be difficult for us to plant the mitigation on site before we do the construction.
Brought up another question on that. Are you planning on doing the bank, or are you doing mitigation to the bank?
We haven't got that far. It's likely going to be a combination, but there are quite a bit of landscape buffer requirements here, so we'll be up there, and we'll work with staff on that, but we'll probably maximize the mitigation on site as best we can.
Mr. Marchant.
Thank you, Mr. Chairman. A couple things you mentioned during your testimony was you've maxed out the site for maximum use, right? So if you get approval for the additional story, then all the parking and is this working? Can you hear me? I'm sorry.
Yes, sir, I can hear you.
And all the parking and all the retention is accommodated in this plan, right?
Yes, sir.
If you don't get approval for the additional story, you don't need as much parking, which means you may not need as much site retention, in theory.
I will let, I can let the owner speak to that or the architect, but
Right.
the additional, my understanding of the additional stories are for storage and for staff movement. Makes no impact as far as the parking requirement or the footprint
Okay.
of the parking.
Fair enough. So, but back to the maximum use of property, you've got 2 out parcel buildings here that require parking as well, and that's, I'm sure, for additional income and whatever. And it's back to the question that Mr. Neal asked, which I'm struggling with, which gets, again, to criteria 3 and criteria 6. And our judgment is based on criteria, not anything other than that. One of the best, I think, arguments for your case is showing additional site plans that also don't work.
Sure.
We've had cases in the past. There's a car dealership just down 17 from this project. Interestingly enough, which a lot of people in the revitalization world did not like, but we still approved it, that had tree issues, parking issues, and the challenge to the applicant was get creative with your design. And they came back and they got creative and they made it work, and it's better, and the neighborhood's happier, and everybody's happier. So my question is, how can you tell us with great faith and confidence that there is not another way to deal with this and save that tree, including minimizing building footprint and minimizing outparcel buildings? I mean, that's, I think, did you cause this problem or not is really before us. And could you use the property differently? Because that's what we're judging this on.
Sure. So the outparcel buildings actually came about because of the county ordinance. The way the ordinance reads, if we were not going to have these outparcel buildings, that hotel would have to be adjacent to Highway 17, which is just, my understanding, is not a good planning practice. We don't want a 7-story building right off of 17. That would require the removal of the 55-inch oak as well. So it's, these other site plans we can look at. Not saying there isn't a site plan that doesn't require the removal of that tree, but it's not the best use of the property. And so that's where the way the ordinance is written, if the outparcels go away, that building moves forward, and we're coming back here requesting for the removal of the tree as well. So we've been working on this for over a year now, and we've done quite a bit of research on the property and entertained quite a few site plans.
Go ahead, Mr. Williams.
Quick follow-up to that. You have entertained quite a few site plans on this hotel, correct?
Yes, sir.
For this hotel, but not other kinds of businesses or anything like that?
Not to my knowledge, but they may have been prior to my involvement.
Okay, thank you.
Anyone else back on this side? You? Yes, sir.
Yeah, so can you describe some of the work you guys have done with the Revitalization Commission and the city, and presentations and responses that you've received?
I may kick some of that to Mr. Palacis. I personally was at the Revitalization Commission. Mike Remesey with R4 presented the project. They handled a little bit more of that than I did.
Okay.
Any more questions for this person? Thank you, sir.
Yes, sir. Thank you.
Anyone else to speak in favor of this application? It's going to help us. Yes, sir. Please come forward. Please state your name and address for the record, please, sir.
Good evening. My name is Demetrius Emmanuel Palacis. I'm a resident of Charleston. I was born in Roper Hospital 76 years ago. Having said all this, I have been a resident of West Ashley for almost 60 years now. I've been in the hotel business almost that long. And I really have a warm spot in my heart for West Ashley. This property became available to me 8 years ago. I purchased this property, and I knew what I wanted to do with it. I knew we needed a convention center in West Ashley. This is a convention center hotel. This is not a motel. This is not just a regular hotel. This is a convention center hotel. It has 210 rooms. It has a 14,000 square foot ballroom and pre-function area, and a total of over 20,000 square feet. This will change the whole dynamics of this area in West Ashley. As far as the tree goes, the two trees go, one of them is inside the building, and we moved this building all over this property. For 8 years, I've been playing with this thing, trying to get it to the best solution to build this project, and incidentally, it's 10.125 acres, and I've been needing every bit of it, and we've moved the building everywhere, every which way. We've spent a long time and a lot of money trying to figure this thing out. All right, the other tree is in the way of the main entrance, and it's also, if we save the tree, you have such a canopy, we lose a tremendous amount of parking all around the tree base and everything. So, having said all that, this is what we've come up with for almost 2.5 years, ever since even working through the pandemic, and this is the best solution for this property. I really feel like this will be a game changer in this area of West Ashley. We all know that West Ashley needs many shots in the arms. When you compare it with the other suburbs around the city, we feel like we've been kind of left behind over here. So, having said all that, I'm here to answer any question you'd like tonight, and I'm here for you.
Okay. I know a lot of these gentlemen would love to have an opportunity to speak with you. I'm going to start off with probably one of the older members of this group, Mr. Jordan.
Oh, probably. Whatever. So I have no doubt that you don't love West Ashley, but don't you love those two trees too?
Pardon me?
Don't you love those two trees just as much as everything else in West Ashley?
I'm sorry, I can't hear you properly.
I said, you said that you love West Ashley, and I don't doubt you.
I do.
But you love those two trees also, don't you?
I have many trees and many pieces of property we have, and I love a beautiful
We're
oak
only
tree.
talking
I
about
love a
these two
beautiful
trees.
pine tree.
We're only talking about these two trees.
Okay, this tree is in the way. This tree is in the way.
Thank you.
Okay. That's basically it. If it were somewhere else on the property that it didn't interfere with the project, I wouldn't have a problem with it.
Thank you.
Okay.
Anyone else?
Quick question for
I'm doing such a good job, I don't have any more questions.
quick question here.
Mr. Williams.
Sir, so I'm having problems, as I mentioned before, with the need for the variance is not the result of the applicant's own actions. How do you explain that? Because you said the variance request for the grand tree removal is due to the existing site conditions. The architecture variance are due to the non-practicality of following these requirements on a building of this scale, as well as the interpretations of ordinance. So you said, the applicant or somebody said, a building of this scale. That tells me that you could scale down, and it would be your choice, or whether it's the applicant or the developer or the builder or the engineer who said this. How do you explain that?
This is a 10-acre plus piece of property. You can't scale down it for economic reasons. I realize that may not be a reason for y'all to decide which way you want to go for or against it, but it does not make sense. This is probably a $75 million project. Right. Nobody's coming West Ashley and want to put their money where their mouth is, okay? Basically, it's as simple as that.
So we're looking at 7 criteria, and I'm having problems with number 6 here.
Yeah.
So I appreciate your answer. Thank you. Thank you.
Yes, sir.
Thank you for bringing this project to West Ashley, because I agree with you. It needs a shot in the arm, and I think this could be a tremendous advantage and positive for everything in West Ashley businesses. There's obviously some doubt on this board about the criteria for a tree. I haven't heard much doubt about the extra floor. I haven't heard much doubt from my fellow commissioners about all the other things out there. I feel like the tree is coming down to the tree, and that's where I am right now. Will this project move forward if we tell you to save that one tree? Yes or no?
I plan on committing myself, yes.
You answered
to
my
this.
question.
And if for any possible reason, whatever, another pandemic or whatever, okay, God forbid, you know, that would be the only stopping point. And we would never, ever take the tree down without full commitment and full financing.
Question, thank you.
Anyone else? I have a question for you, just out of curiosity. What's going to be the name of the hotel? Or
It is one of the three big names, okay? All right, it's one of the three big names. So you can imagine, it is going to be a convention
You can't
hotel.
disclose it now? Okay.
I tell you, it has two restaurants in it, one on the first floor, and then a rooftop restaurant overlooking all of West Ashley, and a rooftop deck up there as well. It has 210 upscale rooms. This is something very, very nice, something that West Ashley does not have. I'm the only one in West Ashley that's been in business at the Town and Country Inn for 42 years now. I built it 42 years ago. I've been operating for 42 years. I know what the demand is for meeting space and banquet space. That's my whole position.
Okay. You know what, can you do me one other small favor? Please,
Yes.
sir. Could you state your home address, please?
Oh, I'm sorry.
That's okay.
Okay, it's 5310 Stono Ferry Course, Hollywood, South Carolina.
Hollywood. Thank you. I just wanted to make sure we had that for the record. Mr. Jordan has one other question, I believe.
So you are the owner of Town and Country?
I'm the owner of Town and Country. I'm owner of the Home 2 Suites across the street, which I might say I was picked the #1 Home 2 Suites for design out of 167 Home 2 Suites that were built in 2018. Unsolicited. I got the call from the president of Hilton, and I was given the award in front of 3,000 owners at the Hilton convention.
Congratulations.
Do you also own a motel or a hotel in North Charleston?
I do not own them anymore. I sold them.
But did you?
I did. I own the Hampton Inn on Ashton Phosphate and I-26. And my grandfather built the Siesta Motor Lodge 87 years ago.
That's what I thought.
Yeah. And I'd like to also say, my son and I and my daughter and my wife, we also own the Market Pavilion Hotel on the corner of Market and East Bay Street, across the street from the Customs House.
Thank you.
Very
So we're
good.
committed. We're committed to quality.
And we appreciate Mr. Marchant.
Thank you, Mr. Chairman. I feel like I have to make an architectural comment for some reason. And Mr. Palacios, I don't know that if this may not be a question for you as much as it is for staff, and maybe also just a comment for the board, but architecturally speaking, this is a difficult project to comment on because the context of the DuPont, Wapu, 17 South area is a buck with architectural style. I mean, there's really no contextual standard. And the West Ashley revitalization efforts have really gone nowhere since they started, unfortunately. And so I understand the city of Charleston having the DRB that extends out that far, but this isn't part of that. So it's hard to talk about whether or not an additional story matters or not on a building of this scale. I mean, it's big, period, right? I do support the use of your windows and not having punched openings with sills. I'm good with that. I think it fits the building, and frankly, it's better architecture. The challenge for this board, though, is we have nothing to compare this building to or nothing to measure it against because it's not part of anything that we can fairly measure it against from a design review board standpoint, if that makes sense. I mean, the fire station down the street's not big. Even Town and Country's, what, 4 or 5 stories? It's not super big, right? Is that about right? It's just hard to make any comment. It's sort of its own thing that landed on this 10-plus acre piece of property and kind of is what it is. And I hate to say that as an architect, but you know, personally, I'd love to see it on the street. I think urban corridors or high-traffic corridors ought to have tall buildings around them, but we're not going to have that conversation today. So, I don't really have much to say about the architecture because of the lack of context and lack of jurisdiction that the county has with adjacent properties, because it's a missing tooth in the city-owned landscape. So I don't know if that helps, hurts, or even if there's a reason to respond to that. Other than, kind of looking for staff here to guide us here, because the architectural piece of Zeldar is so limited when you don't have a bunch of county properties strung together, if that makes sense. So anyway.
I don't think we have very many projects in West Ashley other than the car dealerships that have done a great job. Right. To compare architecture anyway with, there's nothing outstanding in West Ashley. I also served on the West Ashley Committee, Revitalization Committee, for 4 years. And one of the things I've done more in that 4 years, bringing the town and country up, for a remodel, a big-time remodel that was for a hotel that was built 42 years ago, and the Home 2 Suites across the street is a 5-story building.
Yeah.
Okay.
Yeah.
And 150 rooms.
I kind of wish, I think Mr. Nelson mentioned this earlier, I kind of wish we had some documentation from West Ashley Revitalization Commission that sort of at least help substantiate the direction of the project.
Mr. Martin, just to tag on to that, the one thing that just strikes me about this project is we just had a mobile home request where we had a whole neighborhood come out to speak toward the project, and here we have what would arguably be the largest structure in West Ashley, and we have no letters of support, no letters of opposition. I don't know where everybody stands in the crowd, but I suspect we have a lot of people here that are in support of the project. And it's odd. This is just an odd request. It would just be nice to hear from others with what we're tasked to do tonight, the stance of the City of Charleston, the Revitalization Commission, and all those groups on this project before we really comment on whether or not a grand tree should be removed.
Yeah, and if you recall, and perhaps the county can communicate this to the other municipality that's involved, we had a city council member at a car dealership hearing, and yet, anyway.
And I get site constraints when developing. I mean, in talking about DOT standards, it's a world in which I live in some of the projects that I work on. So I know there are a lot of constraints with developing sites like this, and I know with flooding concerns and lack of stormwater controls from all the development that's occurred in West Ashley, development of this site will be difficult. It will be difficult to control stormwater, and that's going to require a special touch that will have impacts on whatever type of development goes there. But man, I sure would love to hear from some outside folks on this one.
Well, I can say when we had the revitalization open forum and open to the public, it was like overwhelmingly voted for to do the project. No one came out against. One person had a question about access from the highway or driving in and out, of course, but we have that covered as well. And so that went away. And so basically no one said anything against it. And we had a lot of publicity, overwhelming publicity for it. And we had some councilmen from the city of Charleston spoke openly for it. What can we do? These are the questions. What can we do to make this thing happen? How can we get this thing on the road and make this happen? And I can quote the people that said that.
I found the Revitalization Commission website, and y'all did make a presentation back in July of 2022. Unfortunately, the iPad doesn't want to pull it up. It must be too many megabytes or something, or I'm condemned by Charleston County's Wi-Fi, maybe. And I also saw that you had an article published in the Post and Courier. And again, it's
many.
And it's just odd that I don't recall hearing anything about the project and have something of this scale come before us. I'm not saying I'm for it. I'm not saying I'm against it. I'm just saying that's just odd.
Silence is golden, you know.
In many instances, yes, it is.
All right, gentlemen, lady.
Any other questions?
Any other questions? Mr. Pulaski, I thank you for your time and your dedication towards this. Thank you, sir. Yes, sir. Thank you.
Thank you.
Do we have anyone else to speak in favor of this application? Yes, sir. Yeah. Well, whoever wanted to come up, no.
My name is Michael Remesey. I'm president of R4 Architecture. Address is 513A Savannah Highway, Charleston. It's my office address. Before I get into the variance requirements that we're trying to address on the architecture, I just need to speak a little bit to Mr. Palacis's commitment and what we've kind of gone through on the background to get to where we are today. I mean, this isn't just a willy-nilly site plan we threw up here for everyone to analyze. I've worked with Mr. Palacis for over 15 years, and whether he wants to admit it or not, we've worked on this project since 2014. So we've looked at many site plans. Mr. Palacis is a very detailed hotel client. I have other hotel clients that don't go to this extent of concern to detail and orientation and design. They'll just say, let's do a Hampton, throw it down on the site, give me the parking you need, move on. Don't worry about it. This particular project, the way we have the site oriented, we studied that for years, literally. It wasn't just, a couple months and we presented it to you. Every iota of parking, approach, distance, the shape of the hotel has all been put forward by a collaboration mostly by Mr. Palacis, but my interpretation of what, we're going to end up with. The hotel's curved, and no one's ever asked, why do you have a curved hotel? Well, when I did the presentation to the revitalization committee, we basically went through every aspect of this hotel, why it was designed that way, what the benefits were, and how we evolved to the site plan we got and the building we got. I mean, it's more than just the building. Mr. Palacis was very considerate of approaching the building. Most people, let's get a driveway in here quick and get to the porch and park. He wanted every hotel guest to have the experience of approaching the hotel, what you see, what you turn, what you pass, 2 ponds, beautiful trees, lighting, a beautiful hotel that's curved versus your typical straight hotel. So, for what we're presenting today, it's not, a couple months or 6 months of this has been years in the making of getting us to this point today. So I'm not going to talk to the tree because I'm not a tree guy, but the tree was always in question. And I know we're applying for a variance, but in the overall scheme of approach, design, what we have, the experience, the tree isn't an additive to the formula. It sort of takes away from the formula. So just trying to get that through that, again, I mean, the man is worried about where the time clock for the employees goes. And, we're here trying to get a variance, and I mean, the man is detailed. I've never seen anyone like that. Worries about every aspect, how the guest is going to experience it. Is it going to be a positive? Is it going to be a negative? So I don't have any hotel clients like Mr. Palacis. He's one and done. I mean, I wish I had more. And most of them is very simplistic. Give me a hotel. I've been doing hotels for 30 years.
Wow.
So I just want to say the man knows what he's doing. And when he tells me something, I don't argue. I agree. You're right. He's putting his money in it. Every single hotel he's ever been built has been successful. So I don't argue anymore. Some of my other clients, I argue a little bit, not Mr. Palacis. I trust him to the nth degree. He probably knows more about putting a hotel together than I do. I hate to say that. So I just want to get that out there. So you got to take that into account. I mean, it's not, your typical applicant that walks in, after a year, and, I mean, his heart is in this. My heart's in this. I've been doing this for a long time. Anyhow, variances that we're applying for. The story issue. I don't believe we even need to be here for a variance on that. This is a 7-story hotel. The South Carolina Building Code allows mezzanines. You're allowed to have a 50% mezzanine, and it's called mezzanine, not story. So those are, according to the building code, we're allowed. Now, to count levels and say that's a floor, I absolutely do not agree with that at all. So, my question was, I don't think the zoning board, and all respect to the zoning board, can change the definition of a building code feature in the building code and suddenly say, no, a mezzanine is a story. It's not, by definition. So that one, I think, is a no-brainer. I don't see any argument in that. This is my opinion. So I want to address that. The window massing. Again, this goes back to the design of the hotel. When I read the zoning ordinance, again, no disrespect, but I don't think it was written with the intent of a 7-story hotel like we have. Some of the zoning architectural requirements don't make sense to me when you have a building of this size and this design. So we are not going to be doing, at this level, a punched window that's, 4 by 5 with a soldier course header and brick sill. It's just not where we're, at this level of design, we want as much glass as you can get in a room. So when you walk in a room, again, it's guests' comfort we're looking at, not the architectural features. When you walk in that room and you open, your view is tremendous, and that's what we're trying to bring the outside in. So we don't have windows, we have a window system that goes from 6th floor all the way down the grade. So that's why I basically said, and the windows actually, in theory, are inset. The pilasters project 1'4", and the windows are pushed back 1'4". So they are, to the degree of whatever inset means. I couldn't really understand, everyone has their own mindset of what inset means. Is it 4 inches, 6 inches, or 2 feet? I don't think that's addressed in zoning, it just says inset. So ours are technically 4'1" inset from the building face. So wanted to address that. And the massing, I had major issues with. It was saying that for every 750 square feet, you need what's the terminology? A multi-dimensional design with surfaces. If we were to conform to that requirement, every 8 linear feet, being a 6 and 7-story building, we'd have to change the design, whether it was be material or projection. We'd have a candy cane building. So, or if we went horizontally, it would look horrible.
You got about 45 more seconds.
Okay, so I disagree with that. I think our building has enough movement. It's curved. It has a lot of ins and outs. I think it's an interesting building. So those requirements, I think, weren't tailored to this type of building and this size of this building. So we are 7 stories. I don't think there's argument there. You can't change the definition of a building code. The windows to us make perfect sense for what we're trying to accomplish. And the massing at 750 square feet just absolutely be an architectural disaster if I followed that.
Okay. Thank you, sir. Let me see if anyone has a question for you. Mr. Jordan?
And the trees?
What about the
You were
trees?
just making a summary of what's good or bad about this project, but at the end, you didn't mention the trees.
Yeah, well, I said I'm not going to comment because I'm not the tree guy, but in respect to the design, the symmetry, the approach, the tree is kind of offsets the whole approach and the feeling, the emotion. And it is a grand, but it's, I've been by it several times. It's not a beautiful grand, but it's a grand, so I guess we have to respect that.
Thank you.
Anyone else?
Quick question if I can. Sir, so I guess I'm not an architect or anything, but my question is, I believe that the county council sets ordinances and et cetera, et cetera. We're not here to change ordinances. So what are you asking, why are you in front of the board, I guess is my question.
Well, what I'm trying to say is, whether it was staff or what have you, says we have a 9-story building. We do not. We have a 7-story building based on South Carolina Building Code and the definitions. So we're applying for a variance. I don't think we should be applying for it, but that's neither here nor there. Is that what you're asking?
So you're saying that there's a mezzanine at the top on the roof? Is that what you're
No,
saying?
let me explain what we were doing with the mezzanine. The mezzanine is, when you walk in the ground floor, we have 25-foot high ceilings, which for a hotel this size is pretty much a no-brainer. What we've done is put a mezzanine level between the first floor and the second floor, which is a service mezzanine. It's not for guests, it's so staff can move quickly throughout the hotel, because it is a big hotel, and provide the services that the guests require. So at that level, it's purely service. At the 7th-story, that mezzanine is more of a dining mezzanine, because we are going to capture a phenomenal view. Being 7 stories in the air, you're going to see a lot of things you wouldn't see at 4 stories. So we're trying to provide another level for dining guests to be able to capture that.
All right, thank
And
you.
it is a mezzanine.
Okay. Well, thank you so very much for your architectural input.
Okay.
We do appreciate that. Thank you, sir.
Thank you.
Do we have anyone else to speak in favor of this application? I got 2 people moving forward. Good evening, sir. Please state your name and address for the record.
My name is Nick Palasas, live at 2024 Wapu Hall Road, 29412. So I'm the Director of Operations for our company, Palace Hospitality, and Jim is my father. I've grown up in the business, been doing this, starting off as a, teenager working in the business, and I'm like my father, very dedicated to West Ashley. And I see this this building growing up in this area and working in this area. I see this building as becoming a huge catalyzer, and like my father said, a revitalization and a shot in the arm for the area. I ride up and down this street and have been doing it for decades, and there's really not much change. I mean, I was riding down the street 2 days ago, with the exception, like my father said, of the car dealerships that are developing, and you get down toward our end of the area there by 526, and we built the Home 2 in 2000, opened in 2019, and we've revitalized the town and country. We've been there since '84. Aside from that, you still have the same old structures, one-story buildings that haven't really had any type of design or elements or direction. So we really do feel like this is a big key to the area to propel it. Propel is the word, because it's got nothing going on. And if you look at who's put money in this community, specifically within this area of town, in the last few decades, it's we have demonstrated that commitment. So this is a big project, and Mr. Neal, just to clarify, you had a question for my father, asking him about this tree in the front, and just to make sure he understands, you understand. I think you asked him if this tree stayed, would he be committed to the project? Was that the correct question? And you thought he said yes, and it appeared he said yes. But I don't want to speak for him because I don't think he clearly understood you. But with this project being between 70 million on the low end, and it could grow to 80 plus million, if we respect this process, but if it gets extremely difficult, we would probably not do it. Okay, so I know he misunderstood you. And in terms of Mr. Williams, do we have other uses for this property? We're hoteliers, and we don't feel like office space or another strip mall is something that will catalyze this area. I think those things are already done right now in this area. And lastly, there's an opportunity for a convention hotel in this part of town because there's not a lot of options where you can have large events, 600, 700, 800 person events, dinners, and things like that, with the exception of going to maybe 2 to 3 or 4 properties around town, whether it be Embassy Suites North Charleston, Charleston Place. There's just not a lot of options. So this is going to be a game changer for this area, and it's going to help all the ancillary businesses around. So We're ready to do it. We just want it to be relatively, we respect the process. We just want it to be fair, but relatively, on track for good progress. So, and I appreciate your time. If you have any questions, you're welcome to ask me.
Thank you. Let's see if we have anyone who had questions. Thank you so very much for your time and dedication, sir. Yes, sir. Do we have anyone else to speak in favor? You've been trying to get up 3 times, man. Come on up here.
You need to come on up.
My stomach already growling, so come on. Listen. You got a sandwich in your pocket or something like that? I'm just teasing. Please come forward and tell us your name.
Gregory Hamilton. So I was one of the first.
Oh, yes, Mr. Hamilton. Glass Hamilton.
Hey, how you doing, bro?
All right.
Excuse me, do you mind speaking to the mic?
And
Okay.
your name and
I have a hard time
address,
hearing
Mr.
you.
Hamilton.
Gregory Hamilton, 3087 South Shore Drive. So I was one of the first to buy and invest in the DuPont area. And so I built a brand new building, and also I bought another building and renovated it. So, and actually I lost interest in the whole area because it was just a dying area, okay? So Mr. Palacios told me that he was going to build this hotel, and it, kind of give me some more motivation to move forward. Since then, I have another property under contract on DuPont Road, and I think this hotel would be a good plus for the smaller guys like me and Mark to survive in that area because there's nothing there. That's all I have to say.
Hold on, Mr. Hamilton.
Yes, sir.
Anyone else have a question? Okay. Thank you so very much for
All
your
right.
help.
See you.
Yes, sir.
Mark Stein, 3076 South Shore Drive, Charleston 29407. So I am a Charleston resident, lived here most of my life, pretty much within 5 miles from this location on DuPont Road. I also share a property line with this development. I recently invested in a piece of property to upfit and redevelop and to move my small business. West Ashley needs this. West Ashley needs this progress. And, we have somebody sitting with us today that is willing to make the investment and move this part of Charleston forward. I mean, we see Mount Pleasant, we see North Charleston, we see downtown, and there's progress. And we are looking at a real opportunity here. And I'm vested in this area. I've invested, and I hope that you guys make the right decision and you do what's best for West Ashley and people like myself. So that's pretty much it. Make it quick, but thank you.
Thank you. Hold on. Does anyone have a question for this young man? Thank you so very much for your. Did you have a question, Mr. Trussell?
No,
Yep.
I was thinking that I should have asked somebody else a question, but I just failed to do. I wasn't quick enough on my feet.
Okay, I apologize. You're good. Thank you. Do we have anyone else tonight? I think that was the room. I think we emptied the room. Okay. So I don't think there's anyone there, unless I can't see him, that can speak in opposition. Is there anyone to speak in opposition?
You close the hearing. I have a follow-up question for the engineer if I may. If not, if you need to close the hearing, that's fine. It's up to you. Totally at your discretion, sir.
I'll bring him for about 2 minutes. Okay.
Mine's short.
I also have a follow-up for the engineer.
Sorry, Mr. Chair. I didn't mean to open up Pandora's box. My question is very quick. I hear everybody, I am a economic development fiend. I love it. So I'm 100% behind. But we have a structure, being Board of Zoning Appeals, where we have to fit every widget into every box to make it work. And the ones that I think some of my fellow commissioners are struggling on is y'all made this boondoggle, and it's a great boondoggle, but we're trying to get over the hump on at least one of the trees. I don't know if there's any other issues out there, but the one I'm struck on is the 55-inch tree. The other tree is in the footprint of the building. I'm fine. What scenario would you go through And can you come up with a positive solution if this board approves everything except your 155-inch tree? Where are you going to be tomorrow morning? Where are you going to be tonight?
You know,
Are you losing parking? Are you losing drainage?
we're losing parking and drainage. Drainage would be more critical. And certainly at hand is the tree ordinance change. Previously, it was the canopy of the tree. It was the measured canopy of the tree, not the 1 foot per diameter breast height inch. So we're going from possibly a 30-foot diameter to now we're at 110-foot diameter tree save area. So that would be one consideration I would ask the board, if you're leaning to deny that tree, is you possibly consider the tree protection zone to be the canopy of the tree itself, not the way the ordinance is written now. There's gravel right up to the tree, to the base of the tree. Currently, there's also some curb and gutter there as well. So that may be a consideration. If we have to hold to that, to the way the current ordinance reads, we're losing quite a bit of detention and we're losing quite a bit of parking. Can't speak to the feel of the entrance, but Mr. Blas is very adamant that that takes away from his project. But from a solution standpoint, can we find a way around it? We could potentially do so if the board could consider reducing that the tree protection zone.
Have you worked with the arborist here on the county?
We met with him on site, yes, sir. And we work, Natural Directions is the arborist, third-party arborist. On other projects, we can bring in an arborist to help, during construction, things like that, to look at, potential ways to save it or ensure that there's no damage.
Answers my question. I'll wait for the chairman.
He deferred to me for a minute.
Oh,
Mr. Martin.
okay.
Vice Chairman. Earlier, and I'm sorry I didn't ask you this before you sat down, but earlier you requested a different approach to mitigation, which I actually was hoping would go the other way. And what I mean by that is, part of me feels like removing the 55-inch tree has value if there is a progressive strategy to replacing that tree in a different way that's typical than what the county asked for. And what I mean by that is, I heard 3 different people testify tonight about the meticulous design of this site and this building and how wonderful it was going to make West Ashley, and the drive-in and the approach, and these big windows that are going to look out onto this landscape, which right now is just asphalt. But how wonderful would it be if truly there was a garden that you drove through to get to this building, and there was a garden with 6-inch caliper replacement live oaks along Highway 17. That's a mitigation strategy that gets me excited about cutting down a tree, right? And so I say that because creativity comes in different forms, and it's not just about we'll make this work with our buffer and we'll put the tree enough inches back, right? But to come in and say, this is a very formal building, it's a very symmetrical building, the approach to the building by car could be phenomenal. We don't even have a site plan to look at, right? And so I agree with Mr. Neal and some others about the challenge with criteria 3 and maybe 6. What pushes me in the direction of removing that tree is extraordinary site planning that gets me excited about what the future site plan can be. You see what I'm saying?
Sure.
In other words, don't meet the minimum standard, go way above and beyond. And that's the challenge I'm having, because the county's asking you to do that before you even cut the tree down, and you're saying afterwards, and that doesn't give me confidence in what that could be, right?
And I guess from that standpoint, I was talking from a constructability standpoint. If we're putting mitigation trees where a new pond is going or something like that, obviously that doesn't speak to, what you're looking for. But we need to be able to practically construct the site. So it would be any mitigation would be approved you're aware, would be approved as a site plan approval process, and then all of that would be installed prior to the CO. I'm an engineer. I'm a straight line guys. I'm making stormwater work. Mr. Plas is not going to spare any expense on landscape, and he's not invested to build this very nice hotel and then meet zoning minimum requirements. So I'm certainly, I don't want to speak for him, but I think he would be open to having some conditions like that. We're going to bring in high-end landscape architects, and this is going to be a beautiful site when it's done. But my question, or I guess my request, was that we don't plant those mitigation inches prior to starting construction. Certainly, if it's going to be on the entrance, for example, we can't do that until we remove that tree and constructed the project.
I think the county's just asking for, correct me if I'm wrong, mitigation plans, not
Right.
actual construction.
Yeah.
So you would
I'm
have to
so-
come
I'm
in with
sorry, I
plans
misunderstood
for
that.
that
All right, I
prior to
misunderstood.
removal of that tree.
Okay, I'm sorry, I misunderstood.
Maybe
that.
it should say, Sally, the lot of mitigation shall be approved prior to removal? I don't know.
And where I'm going with this, which is a little extreme, is make this awesome. But
I mean, I think that's their commitment.
I know, but that's like a promise that we can't see.
Understood.
I mean, if you came in here with an unbelievable rendering of what a landscape would be, and you said we're gonna go out to that place in Orangeburg and buy these 6-inch caliper trees and do an alley of oaks all the way to the entrance, right along those ponds, which are gonna be surrounded by. We're going, all right, we'll cut the damn tree down. You know what I mean? That's the difference. That's how you. Anyway, I'm probably outside of my scope here, so I'll leave it at that.
Outside our 2 minutes.
No, but you do bring up a good point, something that would be very helpful for us tonight. I'm looking at, probably shouldn't be doing this, but looking at a Live 5 newscast from 8 months ago where there was a tremendous rendering that was done and fly-through of the site. And, we don't have any of that to base a decision on what the context of the site looks like. Now, granted, we have criteria we need to adhere to in order to grant the variance, but I'm struggling with whether or not this board has enough information to grant the variance that you guys are requesting tonight.
I am too.
Even after 2 hours of testimony, which is very, very hard to say.
Say architecturally we might, but maybe not from a landscape standpoint. I mean, it goes back. Y'all been here all night, just like we have. It goes back to our third case with the flag site and lack of information. It's just anyway.
In this forum, and it might not lend itself to the type of presentation you guys may need to make to to show this size hotel or conference center on that property. It's just such a drastic difference from everything else that's in West Ashley.
Sure,
Right?
and I mean, just back to it, obviously it's a handshake agreement or a promise, and not to speak for Ms. Palacios again, but no expense is going to be spared on this, and certainly not on the landscaping. It's and he's talked about it many times, and Mike spoke to it as well, but that guest feel when they enter the property is very high on his list, and it's not, we're not coming in here doing zoning bare minimum landscaping. That's not going to happen. So.
All right, gentlemen, does that answer your question?
Oh, I had a question not for this gentleman, but.
Okay, go ahead.
For the owner that I neglected to.
Go ahead.
Time to ask. Or either you, or father or son, either one can answer these. These are two questions. Okay, go ahead.
Would you please state your name and address again, Mr. Pulaski?
Demetrius Palacios. You want my address again?
Yes, please.
Okay.
My first question is what I would consider as a lawyer to be a friendly question, and it's not intended to be determinative of how I will vote, but I'm just curious. I was persuaded to some degree and appreciative of the support you had from your community. I was thinking in terms of Explore Charleston Visitors Bureau. I think you have their support.
Yes.
In all your projects that you've done. And
Yes.
Is that correct?
Correct.
That's my friendly question. The second the question is, or would you be amenable to asking that we defer for a month or 60 days to allay any concerns that anybody might have regarding your project and trees, or do you want us to have an up and down vote now? I don't have any doubt about your good faith and your professionalism at all. But if some people have some concern, I wanted to make sure that you had a fair opportunity to make sure that they understood exactly what you're going to do. So I'm not sure if that's even a proper question, but would you be amenable, or are you asking us to defer or vote today?
okay? All right, and let me just say this first, that we waited a long time to get in front of you today, you know, almost 6 months. And so having said all that, if conditionally, I would agree with that. I would be amenable. So anyway, but we 30 days, fine. If you want to gather any information or whatever you want us to do on our part, because I think we can show you a lot more that we already have. And especially the entrance and how it sits on the property. And another thing I want to say is you can't get a permit to build the hotel unless you have a complete landscaping plan. And you can't get a CO until you have all that landscaping plan in place at the end of the project. Okay, so that would never be a condition. We would never even get a permit to start with. So that's what that is. But yes, if you want to do 30 days, we'll work with you in 30 days, okay?
I'm not suggesting that you should have to do that. I was just.
I understand that. I understand it. But we want to do whatever it's going to take to get this thing through.
Understand.
Okay? And it's really important for us to stay with our site plan. Like I said, we've been working on this for 2.5, 3 years, and we started back in 2014. So we've turned this building every which way. We tried all the other buildings and everything else. Nothing worked as well as this does.
Okay.
So we're bent on using this plan.
Got it.
So let me just bring out a point of clarity, if I could. Ms. Workins already said that our docket is full for next month, for August. So 30 days wouldn't be within their ability to hear your case. I don't know about 60. Are you saying that they possibly could come in on 60?
Sorry. We don't have a full agenda for that yet, but if you vote tonight to defer, we could save that spot for September. It's September 11th.
Did you hear that? I was just saying that for August, the docket is full, but for the following month, there is space that we could hear your case again, if you so desire.
Put us in. So we'll see you in September, is that what you're saying?
That's what I'm understanding from
You
staff.
have space for us in September?
Oh, sorry. Yes, if that's how they would like to vote.
Okay. All right. Thank you, sir. Any questions of him before I dismiss him?
Mr. Chairman, just point of clarification. I appreciate fellow commissioners' option to Mr. Palacios, and I certainly don't deny his right to defer. There is a potential that one of these cases could be approved. I mean, this is all risk, right? There's a potential that both could be denied, and that's why the fellow commissioner made the offer. I just want you to understand as the applicant that when you come back, the strategy for either asking for an additional variance or creating the capability to keep that tree is going to be really important, because I mean, I made one suggestion, right, which was a really great landscape plan that maybe goes above and beyond typical mitigation could be a great thing for us to hear. But my fellow commissioners may not agree with that. And another strategy is don't ask to take the tree down. But not all my fellow commissioners may care about that either. So I just want to, I'm saying that out loud. I just want to share that because I think it's important that we do what's in your best. You got to do what's in your best interest. And I know it's hard to do that because we haven't made a vote or even had a motion yet. So that's all I wanted to say, Mr. Chairman.
Thank you. Yes.
I'd support what Mr. Marchant said. I was just thinking out loud that we could make a motion to approve today. And
well, you have two different cases that we're looking at that each have to be voted.
We can't canvass everybody.
Okay.
Yeah.
Right. My point was we have two cases. they could go either way. They could also both be requested to be deferred. Or one could be requested to be deferred. That's all I was saying.
There's no guarantee he can come back in 2 months and it gets approved necessarily. That's to your point.
We should vote tonight.
So, all right. Do we have any questions of him before we finish? Any? No?
I just want to clarify. Mr. Palacios, are you, I won't say it under the board's advice because that's not what they do, but have you made a decision to ask for a deferral of one or both of your matters before the board tonight?
Basically, are you saying on both of these issues?
I'm asking you, sir. So, because we need, the board needs to hear from you.
We need both of these issues to pass.
But are you?
In order to build this hotel.
Okay. Are you asking for a deferral?
And if it takes a deferral to meet your needs and to meet our needs, yes, we have no problems with that. But like I said, we don't want to be stretched out another,
No, there's room on the
indefinite time.
There's room on the September agenda for you to come back before the board, and you or your team could discuss additional information with the staff that could be presented.
No problem.
Okay.
We're at their disposal.
All right. Thank you, sir.
Thank you for clearing that up.
Anything else?
Anything else?
I was just concerned that we clarify for him what
did.
he's expected. Yeah,
He just did.
expected to bring when he comes back.
Well, Mr. Chairman, I apologize if I'm getting into the weeds here on procedure, but perhaps clarifying any and all possibilities, Mr. Hugie, in terms of, we could have a vote tonight and both could pass. We could have a vote and both could deny, and he could appeal. And there's a process for that, right? And so I just want to make sure the applicant understands all avenues so that we're not wasting his time or our time. That's all. And if I'm speaking out of line, I apologize.
No. Go ahead.
I mean, I don't want to make this too technical. So, and I apologize, sir. Your options are to move forward with both cases and have the board vote on both cases. It can be approved, approved with conditions, or denied for either case. For any decision that is denied, you have the right of appeal, which you would appeal that to the circuit court, and you would have 30 days to do that notice of appeal and then file an actual appeal, which would go before a judge, go before a circuit court judge. And that process, it may take much longer. So I'm not giving you legal advice. One of the board members have just asked me to make sure you are aware of your options. The other option is to ask for a deferral, and if you still want the deferral, both cases can be heard in September, and what I would offer to you is to speak with staff to understand the additional information that the board is looking for to render a decision. I'm not saying it's a decision to pass or deny, but to render a decision, it is my opinion that the board is looking for more information that may result in a favorable decision for you and your project. And so that additional information, staff, Jenny, is clear on what the board is looking for. Do you have any questions, sir?
Yes.
Okay.
If I agree to deferral, is what you asked me to do, okay? Or this is one of the options out here, all right? Deferral. And come back and I'm denied. Did I relinquish my ability to go to
appeal.
circuit court?
No, sir.
Okay.
No, sir, because no decision has been rendered. So once the decision is rendered, if it is a denial of one or both matters, you have time. Your time to appeal starts from the point in which the decision is mailed to you.
I understand, but as long as I don't lose that opportunity.
No, sir, you will not. That's procedural, and you will not lose that.
All right. I agree to deferral. for the September meeting.
Thank you, sir.
Thank you, Mr. Hugie. So at this time, the applicant has asked to have both cases deferred for 60 days that will be held and heard at our September meeting. At this time, I'd like to get a motion to approve this deferral.
Motion to approve.
Who?
I'll make the motion.
Okay, would you make the motion?
I would make a motion to grant the deferral.
Yes.
It seems like it's a very fair thing to do out of respect for the property owner, hopefully for the success of this project and to allay any fears or concerns that anyone may have about the project.
May I have a second? So, okay, Mr. Nelson is giving me a second.
This is for both?
For both. For both. Thank you for that point of clarity. All right, any discussion?
I do want to clarify something, Mr. Palacios. So generally, you can defer for up to 90 days. I'm not telling you have to. You can still be heard on the September meeting, but if you want to have the up to 90 days rather than the up to 60 days, just in case there's an issue, you may want to allow the board to give you up to 90 days, but we have on record that you want to come back in 60 days. That's your choice, sir.
Well, of course, if we want to do it in 60 days, okay? But to accommodate both sides, I'll go along with that.
Okay.
all right? I'll go along with the up to 90 days. Okay. Only if we have a problem getting on the schedule from either your side or my side. But I don't believe you're going to have a problem from my side, okay?
All you have to do is confirm with staff that you want to be on in September. I just didn't want you to have an issue, miss that, and then there's an order from the board only giving you 60 days. All right?
The only thing I have to say is my 53rd anniversary is September 6th. Don't give me that date.
Mr. Truslow, if you would just recant, giving him the full 90 days.
I'll make a motion to give the property owner up to grant his request for a deferral for up to 90 days. He expects to be able to respond within 60 days. And that would be my motion, and I've already stated the reasons.
I'll accept that.
And we have a second for Mr. Nelson. Okay, any discussion? All right, very good. All those in favor, please indicate by saying aye and raising your right hand. Aye. Any opposed? No one opposed. Your deferral has been approved. Thank you for your time and everyone's effort and input into this case tonight.
Thank you very much.
Thank you. Board members, this concludes our meeting for tonight. Ms. Working, do we have any administrative information that we need to disseminate?
Yes. So, like I said, we do have 10 new business cases, and not only are we maxed out, but there's a potential that 4 of those are going to be controversial. One being in mine, and others being a big tree project on John's. Yeah, so it's that Lofton Road vine. I don't think any of the new members heard that one, but it's a new case though because they added a second parcel for their access off of 17 North. So that one's on the agenda for August, and then we have a big tree project, Kane/River Road, that requires 3 kind of different tree variances.
Does that anything to do with that mine project in the past? Oh, no.
It's right by the school. What was that? School? Yeah, the school. So my question then is, knowing that it might be a long meeting,
Do we want to start early?
do you want to start at 4?
Yes.
We couldn't do that today because planning commission met today, but we can do that in August. September will also be a double dip for planning commission. So,
All right, so the suggestion has been made to start early at 4 o'clock. Would that be a problem for many of you? At least we're going to need to have a quorum.
Right.
I know you may not.
I may be late.
okay.
Sorry, what was that date one more time?
August 7th, as long as I know I have 5, 6, 7 people, I would feel comfortable, and then if people need to come late, that would be fine.
Okay. So we're in agreement with that, pretty much? Okay. So that's good.
Yeah, and then Mr. Seidel finished his training, thank you. So I'll update this slide for next month.
Good job.
What do I need?
And
Send
then
me an
just-
email. Whatever I need, just send me an email.
Oh, okay, yeah. Yeah, sorry. Sorry, and then, go ahead.
Chairman, I left this whole discussion with, not sure that we looked at Mark's point about a wild landscape plan to offset the loss of the tree. I just want to make sure staff, I mean, that's kind of what I'm hearing we need to see. And I'm not sure if that was completely understood. I don't know. I think he did. He's a developer. He should have got that. But when the staff talks to it, I think that clarity about not just, I mean, something that really it fits into his vision for this hotel.
Yeah.
Clearly from what he expressed, but
But
I think it's important to reemphasize it, so.
Sure, but staff
That's what
has
I
to be
was
careful
thinking. I said there
because
was so much.
you're not giving what I'm going to call advice.
Yeah, we're not supposed to do
So,
advice.
such that the board is just rubber stamping. So we cannot give the impression to an applicant that just do this and the board's going to approve it. You can give them advice.
What is that
as
called, the
general
quo
advice.
pro?
What we're looking for, the items that will help make a decision.
Direction. I mean,
Quid pro pro.
my comment was related to, there's mitigation
Right.
strategies.
It's gonna be required.
It's minimum standard,
Yeah.
and it's knock your socks off. And if you're gonna,
Yep.
if you're spending $75 million on a project, spend $300,000 on some awesome trees.
Yeah, and they also will have access, these meetings are on YouTube, so if they want to go back and listen to anything that was said, we have to do that all the time, just for the finer points.
They do have the ability to show some of the videos and renderings that they've done of the property and
Yeah.
the project. I mean,
Yeah.
And then it becomes evidence. You gotta
Yeah.
do it. Like, we had no evidence tonight.
and if you look at some of the articles, I mean, it's all there. We just didn't have it tonight.
Yeah, yeah. I only have one other announcement, and it's kind of sad, but Jennifer Stiles is moving on, not Sally, but Jennifer
I was
Stiles.
looking for her, but obviously she's not over there.
Yeah, I know. Like her last day, I think, well, this week is her last week, but she's going to do maintenance plans for the Air Force Base, kind of using her site plan review and architectural background. And she's really excited about it, but we're all really sad. I'm sorry? Yes. Yeah, yeah. So we will miss her and hope that maybe she'll come back.
Don't nobody else leave.
At some point. But yeah, that's it.
Is that it?
Yep.
Meeting's adjourned. Thank you, guys.
Nice.
Chair, good meeting.
Yeah, then
You got a motion like that. You just can't.